proceeding. Bench 3 matter.
Okay. No.
7.
Disciplinary proceeding.
Yes, ma'am. Disciplinary proceeding. Again, the inquiry report appropriate court, ma'am. Bench 3 matter.
Yes, Mr. Borua. Oh, this corporation. Corporation.
Yes, ma'am. Corporate.
Mr. B. Sinha, Learned Counsel for the petition. And Mr. L. Borua, Learned State Counsel have submitted that the subject matter of the petition party to bench the registry to verify and thereafter leave the list for the appropriatements.
May I please, Lord? My Lord, I beg to mention the listing of one admission matter, my Lord, next week, my Lord, next 31st.
Fine. What is your subject matter?
My Lord, regarding construction of a road by deviating the existing one, my Lord. Obligation.
Lordship, I beg.
Item number 21, my lord.
21. Yes.
In this case, my lord, I have filed an IA, my lord, for implement of the resolution number 9 and 10. So this is not on record, my lord. So I have also obtained the consent of the other side, my lord. To come up on Monday next week, along with this.
Mr. H.I. Chaudhary, Learned Counsel for the petitioner, has submitted that an interlocutory application. Any number
No, my lord. We have filed on last item.
has been filed seeking implement of a party respondent. As the said interlocutory application for implement is not listed today, he has paid for listing of the case on another date
On Monday.
with the said interlocutory application. It is submitted that content has been taken from the Learned Counsel from the other sites to make the prayer. But he is allowed to leave the case along with the interlocutory application for implement stated to have been filed on next Monday.
There is an interim order that will continue.
The interim order passed earlier
Obliged.
shall continue till the next date of listing.
Lordship, I beg to mention item number 36. Lordship, matter may be taken after 4 weeks.
Lordship, I am appearing for the petitioner here. Otherwise, there is an interim order in play. I don't have any objection.
You are for?
GST, Lordship.
Okay. For Kyle.
Yes, Lordship.
Okay. Mr. D. Bora,
Yes, my lord.
Learned Counsel for the petitioner is present. MS
M. Deca.
M. Deca, Learned Counsel appearing for Mr. S.C. Kyle. Learned Standing Counsel. GST. For the respondents has paid for and is granted 4 weeks time to file counter affidavit
Start.
on behalf of the respondents. Place the case accordingly after 4 weeks. The interim order passed area shall
Your Lordship,
continue
if I may
till the
pray
next
for a short date, Your Lordship, 13th of February, because Mr. Rohan Shah he is leading this matter. 13th of February, Your Lordship.
26 to
Obliged.
Obliged, Lord.
Please, my lord, item number 53 supplementary plus
50?
53 item supplementary, my lord, for withdrawal.
okay.
Yes,
If you
ma'am.
mention,
Yes, my lord.
you mention,
Yes, my lord.
wait for the mention time.
When
Let the mention be over.
Yes, ma'am. I'm mentioning, my lord.
Yes, please,
that we withdraw.
please.
Interim order may continue in item number.
Already continued.
Highly
May
obliged.
please, Your Lordship. Lordship, I beg to mention item number 45, Your Lordship. I am on behalf of Mr. P. Bodlo, Your Lordship, for the respondent in that matter, Your Lordship. Lordship,
45.
45, Your Lordship.
Yes.
Lordship, may I pray that the matter may be taken up after 2 weeks, Your Lordship. Certain instructions are awaited, Your Lordship. Like,
You are for the respondent.
yes, for respondent, Mr. P. Bodlo, Your Lordship, on
Okay.
his behalf, Your Lordship.
Mr. Roman, you are there. Mr. B. Roman, learned counsel for the petitioner is present. Mr.
KJ Saikia, Your Lordship.
Okay. AJ Soikia, learned counsel appearing for Mr. T. Bodule, learned counsel for the respondent number 6 has paid for listing of the case after 2 weeks. It is submitted by Mr. So-and-so. That consent has also been taken. Under Land Standing Council, Proportion Department and the State Council to make the prayer. Also, Mr. B. Roman has also, Mr. Roman has also agreed to the prayer. Please, prayer is allowed, leave the case after 2 weeks. Only 2 weeks later. The interim order passed again shall continue till the next date of listing.
Deeply ordered.
May I please, Lordship? Lordship, I am praying for listing of a matter for withdrawal, Lordship. For on tomorrow.
Tomorrow,
May I present? Lordship, I beg to mention for listing of a case, Lordship. Because the list on
subject matter,
Power Grid Corporation has occupied the plot of land, Lordship, without following due process of laws. For which,
motion.
no, Lordship, admission is there.
I love. Okay, court master will give the date.
My pleasure, Lordship. Lordship, I beg to mention item 23 and 24, Lordship. Lordship, I have obtained consent from the other side. Lordship, I need
23, 24,
If I need some accommodation for today, matter may come up after 3 weeks, Lordship.
3 weeks.
3 weeks,
Lordship, can it be on 13 or 15 February, my lord?
15.
After 3 weeks,
But 15,
21 meter, my lord.
I doubt 21 matter survives. I have asked to get clarification from the division bench
Yes, my lord.
that 21 matter has not been set aside. Judgment has not been set aside.
Yes, my lord.
So it is you who has to get the clarification whether it has been set aside. I cannot touch item 21. Otherwise, I have delivered my judgment. You are for
I am for the petitioner, my lord. Design.
I'm for the respondent.
Mr.
society.
DJ Medhil and counsel for the petitioner is present. Ms. A. Taluja,
Lordship,
learned counsel appearing for the
respondent.
private respondent. Society
Lordship, respondent.
has paid for listing of the case after 3 weeks. It is submitted that consent has been taken from all the respondent, all the other parties to make the prayer. Full stop. The prayer is allowed, leave the case says after 3 weeks.
Lordship, date may be fixed.
Please, Your Lordship, I beg to mention item 38. My senior is having some personal difficulties. We have taken the consent.
38.
Yes, we have taken the
Yes.
consent of the other parties.
What is your prayer?
Adjournment,
For
Lordship.
a day?
Yes.
Okay, on the prayer of MS Tinlung. Learned counsel for the petition, the case is passed over for the day. It is submitted that consent has been taken. So and so.
Interim is Your Lordship.
Interim order. Hello? Shall continue till the next date of listing.
Obliged, Lordship.
May I please, Lordship, I beg to mention item number 15. Here, conducting counsel S. Bora has some personal difficulty.
15.
Yes, 1-5.
Okay. Mr.
I am C. Talukdar.
Mr. C. Talukdar, learned counsel. Appearing for the petitioner is submitted that the conducting counsel, Mr. S. Bora, has some personal difficulty today and the matter be deferred for a
Lordship,
week.
kindly fix a date if possible, 9
Let's-
February.
As sought for by the learned counsel for the petitioner, is the case on 2-2.
9 February if possible.
Why motion made at 2-2?
Deeply,
Mr. S. Bora or what? MS S. Bora?
Mr. S. Bora.
He's always available.
No, this is another one.
Another.
Yes.
As Bora.
Okay,
As
deeply
well.
obliges.
Lordship. Well, I'm making a prayer for upgrading one item 46, my lord, but I'm making myself clear, my lord. No consideration on merit is necessary. My lord, only a leave is required from your lordship to take fresh steps, my lord, in the addresses that have been given.
Okay, we'll take up your case.
That-
Keep somebody here,
Yes, ma'am.
if fresh steps, but
Can we-
we
can-
generally don't upgrade.
No, my lord, yes.
I don't
Your
generally, I
lordship,
don't make any exception.
Because otherwise, my lord, private respondent is there, my lord.
Okay,
And there is also a direction
take
for
up-
early disposal.
we'll take up
My lord,
before the business hours.
my lord, my lord.
For withdrawal item number 53.
Yes. MSDC now. Learned counsel for the petitioner has submitted, on instruction, that the petitioner doesn't want to praise the writ petition. In view of Mr. S. Borwal and its junior government advocate, Assam. For all the respondents, is in attendance. In view of the above submission made by MS Sinha, and counsel for the petitioner, the writ petition is dismissed as not placed.
For motion item number 1.
Please, your lordship. Last occasion, we prayer for implement of the private respondent, the legal heir of the Fattadar.
Hmm.
But the petitioner could not provide us the proper address of this Fattadar. So we need some time.
But the case is regarding occupancy tenant.
Yes, lordship.
We cannot do anything about a occupancy tenant, how to declare. It is completely within the domain of the deputy commissioner. A proceeding is pending,
Yes,
is it not?
Yes.
We can only observe that this should come to a culmination. Otherwise, as it appears,
Lordship, we
what you have submitted,
Yes.
that you do not know the address of the owner, come to page
Not-
44.
Not, it is not lordship. The legal heir of the Pattadar, Vanamari Das, lives in Guwahati, not in village resident.
Hmm.
And the petitioner could not provide proper address, postal address, but he know the,
Are you, otherwise, there is a proceeding, if we go to page 44, there is a proceeding between you and opposite parties. This is your document.
yes, lordship.
আবেদনকারী রিপিন গোয়ারি প্রতিপক্ষ, there are 6.
Yes,
The
lordship.
proceeding is pending regarding occupancy tenant, right? It is going on since long. That should come to a conclusion. We cannot grant you the prayer made in the writ petition. Let us see. Mandama should not be issued by directing the respondent authorities, particularly respondent number 2 and the respondent number 3, to issue Rayati Patta or occupancy right
Yes, lordship.
under section 6 and 23. Now, if you read section 23, it is the exclusive prerogative of the deputy commissioner to grant occupancy right, which function we cannot take over. We can only observe that proceeding which has been pending before the deputy commissioner should be brought to an early conclusion.
Hmm.
Because in the proceeding, your opposite parties are also there already. Notices have been sent. Page 44.
Yes, lordship.
And if thereafter, if you agree, if you somewhat agree, suppose grant is not made, then there are other remedies.
Okay.
We cannot run two parallel proceedings.
Lordship, I asked the petitioner, he asked me to take some time to provide address.
No, we are not requiring address. Though on first glance we thought that, but since a proceeding is pending and we cannot take over the function of the deputy commissioner, what has been vested exclusively on him Even the state government cannot grant occupancy right. Only the deputy commissioner can grant. And he is in season of the matter. Only thing, proceeding should be brought to an early conclusion. This way or that way. Is it not? He won occupancy patta, tenancy right. If you read section 23, it is deputy commissioner. Yes, Mr. Yes. Lordship was right in holding. So we can only observe that
Yes.
the proceeding which has been, if you come to page 44,
Yes,
this
I've gone.
circle officer, I don't know whether he has the right, but he has initiated proceeding. Abed inquiry is the petitioner
Hmm.
claiming occupancy right.
Hmm.
And he has issued notices to the
Other part,
legal heirs of the erstwhile owner
owners,
under whom he started his
occupant.
occupancy as a tenant.
Yes.
So neither the state government can grant him, nor this court can grant him.
Deputy commissioner.
It is the deputy commissioner only under section 23.
Yes.
Since he is already season of the matter, we can only observe that this proceeding should be brought to a logical conclusion.
Oh, yes,
That
yes,
could be your submission.
proceeding may be expedited.
Expedited. And preferably within a period, particular period.
Yes, that would be more appropriate.
I think that is the best.
Yes, yes.
Landlord song. If thereafter the petitioner is aggrieved, then it will be open for a petitioner to take appropriate remedy under the law. Yes. Heard. B. Sharma. D. Sharma. Learned. Counsel for the petition. You have wrongly stated in paragraph 11 that this Joyamoti Das and others had filed that case 690. Paragraph 11, read.
That the petitioner begs to state that in the meantime, Srimati Joyamati Das, wife of late Banamali Das and Sri Devadas Das, Sri Munindra Nath Das, Sri Dimbeswar Das, Sri Pulin Das, Sri Bhushan Das, all are sons of late Banamali Das, filed a case being case number 690 before the circle officers of Theveri Revenue Circle.
But page 46 says Abedankari is Ripin Goyari. Yes, MS Hazarika. What is your submission?
As per, Lordship, page 44 says that the applicant is the Ripin Goyari, Lordship. Relating to stop process the sale and purchase for the plot of described the schedule below.
MS Z Hazarika. Learned Standing Counsel Revenue Department for the respondent number 1. And Mr. S. Borua, Learned Junior Government Advocate Assam for the respondent number 2, 3 and 4. Volume 3 for Nigi. Has volume 3 for page 245. In this writ petition, instituted under Article 226 of the Constitution of India, the petitioner has claimed that on 26/1/1986, comma, he was requested by one Bonomali Das to cultivate 2 plots of land dash first Roman 1, first plot measuring 20 bighas, comma, covered by AP patta number 4. And dag number 91, comma, and 2. The second plot measuring 6 bighas, 4 kathas, 12 lesas, comma, covered by KP pattern number 4 and dag number 93. Yes. That is, comma, a total of 26 bighas, 4 kathas, 12 lesas, situate at village Bharegaon, comma, Mauja, Paka, comma, whatever Avenue Circle, District Borpeta, within bracket, the subject plots, comma, for short. To cultivate continuing US river, to cultivate petition. So the petitioner has averred that since 1986, he has been cultivating the subject plots. He has been carrying out cultivation in the subject plots till date. Software. It is the further case of the petitioner that claiming the petitioner has claimed himself. Petitioner has, comma, does, comma, claim himself to be a tenant within the definition of subclause subsection 17 of section 3 of the Assam within bracket temporarily settled areas bracket close Tenancy Act, comma, 1971 within bracket the Tenancy Act 1971 for short. Full stop. Claiming himself to be a tenant, comma, the petitioner had submitted an application before whom? (410) Annexure C. Annexure C. What is the Annexure C?
Okay.
Page 39. On 4/10/2017, before the district revenue authorities seeking acquisition of ownership rights in respect of the subject plots under the provision of Section 23 of the Tenancy Act 1971. In support of his such claim as occupancy tenant, the petitioner had submitted the land revenue paying receipts, a number of land paying revenue receipts, and a certificate from the concerned, from the mojaler, Paka Moja. Full stop. The said application seeking acquisition of ownership rights, it has been stated that said application has been registered as case number 690 by the at the office of the respondent number 4. Full stop. The petitioner has further claimed that since he has been cultivating the subject plots for about 35 years, he is entitled to be granted the ownership rights as per the provisions of the Tenancy Act 1971. More particularly, Section 23 thereof. Full stop. The petitioner in this writ petition has averred that despite initiation of the proceeding by case number 690 and issuance of notices to the legal heirs of the erstwhile of the petitioner's erstwhile landlord, late Bonomali Das. The proceedings of case number 690 has not been brought to a logical conclusion despite elapse of more than 5 years since institution. Full stop. In this writ petition, the petitioner has inter alia sought for a direction to the respondent authorities, more particularly, the respondent number 2 and the respondent number 3, to issue Rayati Patta stroke occupancy right in his favor, claiming himself to be legally entitled for the same as per the provisions of Section 6 and Section 23 of the Tenancy Act 1971. Full stop. Para. Section 3 within bracket 17 has defined, has contained the definition of quote unquote tenant, and quote unquote tenant means. Page 252. As per Section 5 of the Tenancy Act 1971, a person who for a period of not less than 3 years has continuously held land as a tenant shall have a right of occupancy in respect of that land full stop. Subsection 3 of Section 5 has provided that a person shall be deemed, for the purposes of Section 5, to have continuously held land under a landlord, notwithstanding that the particular landlord under whom as per subsection 4, of Section 5, a person shall be deemed, for the purpose shall be deemed to have held as a tenant any land held as a tenant by a person whose heir he is. Full stop. As per the provisions of Section 6, quote, quote unquote, incidents of occupancy right, bolded to us. An occupancy tenant shall have permanent, heritable and transferable right of use and occupancy in the land of his holding, subject to the other provisions of the Act. It has been set forth in Section 21. Of the quote unquote heading to that notwithstanding anything to the contrary in any law, custom, or agreement, an occupancy tenant personally cultivating the land of his tenancy, shall be entitled to acquire the rights, titles and interests of his landlord, called as quote unquote the ownership rights, according to the provisions of Section 26 within bracket 1. Subsection 1 of Section 23 reads as under 23 bolded লিখনি আছে আৰু subsection 1 লিখি দাও. It is para. it is found that the petitioner has already submitted an application under subsection 1 of section 23 of the Tenancy Act 1971. And the same has been registered and numbered as case number 690. Full stop. From the notice dated 18/1/2018 issued by the respondent number 4, appended to the writ petition, it is further noticed that it further transfers that the respondent number 4 has already issued notices to the legal heirs of the petitioner's erstwhile landlord, late Bonamali Das, for their appearance before him on the claim made by the petitioner for acquisition of ownership rights. Full stop. It is a grievance of the petitioner that the proceedings of case number 690 has not been brought to any conclusion despite elapse of more than 5 years since submission of application by him under section 23(1) of the Tenancy Act 1971. Full stop. Ms. Hazarika and Mr. Borua, Learned Council appearing for the state respondents, have submitted, in addition, that procedure has been prescribed. Procedure has been prescribed for disposal of an application filed under section 23(1) of the Tenancy Act 1971 in the Assam within bracket temporarily settled areas bracket close Tenancy Rules 1972 within bracket the Tenancy Rules 1972 for short. Full stop. Since the respondent authorities the respondent number 2 and the respondent number 3, respondent number 3 and respondent number 4, Deputy Commissioner, sorry, 2. Since the respondent number 2, 3, and 4 are in season of the proceedings as regards the ownership right of the petitioner in case number 690, the writ petition can be disposed of, at this stage, with a direction to the said respondent authorities to bring the proceedings of case number 690 to its logical conclusion. Full stop. From subsection 1 of section 23, it is evident that it is the Deputy Commissioner It is the jurisdictional district commissioner, which is earlier known as deputy commissioner, who has been empowered, who has been specifically empowered to declare that an occupancy tenant has acquired the ownership rights free from all encumbrances. Full stop. From Rule 10 of the Tenancy Rules 1972, as per rule, the district commissioner, earlier bracket of the district commissioner, deputy commissioner, on receipt of an application, has to cause an inquiry and make an inquiry to satisfy himself about the eligibility of the applicant to acquire the ownership rights before ordering further proceeding. Full stop. If the deputy commissioner, district commissioner, is satisfied that there is a privacy case for acquisition under section 23, he is required to serve notices to all persons mentioned in the application at the applicant's cost, and to any other person or persons, who, in the opinion of the district deputy commissioner, or deputy commissioner Rakibo, presently district commissioner, are interested in it. So the deputy commissioner, as per Rule 11, the deputy commissioner has to hear all objections presented before him, and to make a memorandum of the evidences, if any, adduced by the parties. For the purpose of such inquiry, he has been given all the powers of a civil court. It is after completion of the inquiry, the deputy commissioner has to allow the acquisition of a parcel or parcels of land by the applicant by passing a formal order in the proceedings to that effect. Full stop. The Tenancy Rules 1972 have provided for have also provided for subsequent procedures. Full stop. Reverting back to the facts of the case in hand, it is noticed that after registration of case number 690 on the basis of the application submitted by the petitioner as an applicant under section 23(1) of the Tenancy Act 1971, the respondent number 4 has already issued notices to the legal heirs of late Bonomali Das, the erstwhile landlord, under whom the petitioner has claimed to have become the tenant in respect of the subject plots. As the deputy commissioner, as a jurisdiction deputy commissioner has been provided, has been specifically empowered to grant an application submitted under to grant ownership right on the basis of an application submitted under section 23(1), comma. The direction. This court is of the considered view that any such direction is not any such direction sought for in the writ petition is not required to be considered in a writ petition which the petitioner have initiated as a parallel proceeding. Full stop. This court has found force in the submission of the Landes State Council that a direction can be given, considering the fact that the proceedings is pending in the form of case number 690. Comma, a direction can be given to the respondent authorities, more particularly, comma, the respondent number 2 and the respondent number 4, 2 to 4, to bring the proceedings of case number 690 to a logical conclusion as expeditiously as possible. Full stop. It is accordingly. The writ petition is accordingly disposed of with a direction to the respondent number 2 to 4, respondent authority 2 to 4, comma, more particularly, comma, the respondent number 2, to bring the proceedings of case number 690 comma, initiated on the basis of an application filed by the petitioner as an applicant under section 23(1) of the Tenancy Act 1971 to conclusion as expeditiously as possible, comma, preferably within a period of 6 months from today. Full stop. In the event the petitioner is aggrieved by the formal order passed by the said respondents at the conclusion of the proceedings of case number 690, it is open for the petitioner to take appropriate resort to appropriate legal remedy as permissible under the law. There is a provision for appeal. Don't come with a writ petition again. Then it will be dismissed with cost. Yes. NHIDCL.
Instruction, we have communicated that some more time required.
Some more time required.
Yes, that's it. Wait for-
I just, yes, Mr. Similar prayer. Okay.
3 weeks.
Mr. Rava. Rava. You are Mr. Rava. Boro. Okay, this NHAI and NHIDCL, right? They have a set of guidelines. Suppose 100 bighas of land have been acquired in a particular area. After completion of the entire acquisition process, they find that yes, 5 more bighas are required to be acquired. They have framed the guidelines to shorten the process. Government of India has framed a guideline to shorten the process. 100 bighas are acquired, and say within these 5 bighas are acquired within say 25 to 30 kilometer stretch. At 25 to 30 kilometer stretch, they have assessed the land value at say rupees 50 lakhs. Now this 5 bighas is also within that locality. So 50 lakhs into 5, they pay. Have you understood? You have your own guidelines. Petitioners, 1 katha 10 lesa, 4 lesa already acquired.
Yes.
Now it is your case that you want the balance remaining
1 per.
1 katha 10 lesa at the same rate. It is your case that you want the remaining 1 katha 10 lesa also. Right?
Yes.
And you have started the process also. Why don't you come up with the...
Next year I will come. with the-
Because if he gets the value, he will be satisfied. That is his case.
Because the residential house is there.
If proper assessment is made and proper compensation is paid, if you are agreed also, you can go for enhancement. That is a different case. But if his 4 lesser have been acquired already, money is determined
Lordship.
for 4 lesser.
Lordship. Already paid you.
At the same rate, the balance area.
Yes.
Better you have instruction properly, Mr. Bodo.
Lordship.
Unnecessary, otherwise if you issue notice, it will remain pending for 3-4
I
years.
understand. Next
And
year.
court may pass an order of stay also. If it stays, then your highway construction will also remain stayed for 3 years. You have a guidelines.
Sir.
If Mr.
UK
Decca's 4 lesa land have been acquired at rupees 50 lakh. So his remaining 1 katha land is also to be acquired at 50 lakh. Plus the building. Better come up with the
Assessment has to be come up from the.
whatever, but you say that I will pay the land value at the same rate and the building will be assessed within 15 days time. You can dispose of. Otherwise, you will not get the money for 3 years also. And this national highway construction will also be hampered. That is my view. Otherwise, we will be issuing notice if
No,
you
no,
do not
next-
come up with the
next-
instruction.
Come with instruction.
Heard Mr. E.K. Decca. Learned Council for the petition. MS G. Hazurika, Standing Council Revenue and Disaster Management Department for the response number 1. MSS Borua, Junior Government Advocate from Assam for the response number 2 to 4, and Mr. R. Boru. Standing Council.
On behalf of C. Borala. 5, 6, 7, 8, and 9.
5, 6, 7, 8, 9.
9.
Learned Council appearing for Mr. C. Borua, Standing Council NHIDCL for the respondent number 5 to 9. Miss both MS Borua, Junior Government Advocate Assam, and Mr. Boro appearing for the NHIDCL, respondent NHIDCL, have submitted that instructions are not received in deference to the order dated 5/1/2024. So they have sought how much time? 3 weeks examination will stay.
No, no,
2 week time.
Will stay
no, 2 weeks.
2 weeks time to obtain and place the instructions in deference to the order dated 5/1/2024. The prayer is allowed, release the case on 9/2.
Declare pleasure.
Apply there.
May I please, Your Lord?
Acquisition.
My lord.
Okay. I hired MS SSGR.
Fine.
Learned counsel for the petition. The petitioner had earlier preferred a writ petition. Come on, WBC number 3379/2019. And the same was disposed of by judgment and order dated 28/8/2023. Post of the operative part of the judgment and order dated 28/8/2023, readers under page pencil code. Page 12 code. Pencil code. Page 12 code. In Nilaya, Bagias. Page 12 code. Alleging. So the petitioner has further averred that the judgment and order dated 28/8/2023 was brought to the notice of the respondents on 5/9/2023. While Annexer 2 and Annexer 3 alleging non-compliance of the aforementioned direction, the petitioner has preferred the instant contempt petition under section 12 of the Contempt of Courts Act 1971, read with Article 215 of the Constitution of India. Issue notice returnable in 4 weeks. The petitioner shall take steps for service of notice upon the respondents by registered post with AD within 3 working days.
Obliged.
The order is at my lord, page 16 begins, my lord. The operative part at page 20, my lord. The last paragraph. my
You are
lord.
landowner,
I'm the landowner, my lord.
then read the penultimate paragraph.
Hello.
Read the penultimate. You are respondent there.
I'm the respondent there. my
Read
lord.
the penultimate paragraph.
Yes, my lord. My
If
lord,
the landowners,
yes,
read,
my lord,
read loud and clear.
this matter appear, my lord, page 20, my lord.
Page 21, read
Yes, my lord. If the landowner
last but one paragraph.
yes, if the landowners continue to feel aggrieved in the matter, even thereafter, it would be open for them to approach this court again by filing appropriate writ petition, my lord. But my lord,
You were respondent there.
yes, my lord.
That is why this observation was made.
My lord,
Specifically indicating that
yeah,
you have filed not a writ petition.
yeah, I filed a contempt petition, my lord.
Yeah, okay.
But my lord, there's a direction, my lord, that
Your right has been made limited by this order. and you were respondent.
Yes, my lord, I respond there, respond number 10 there, my lord.
Because of that, this specific direction observation was made. Have you understood
Yeah,
why
I-
this
I understood, my lord.
why this observation was made specifically?
Yes, my lord.
Court was cognizance of the fact that you were a respondent there.
Yes, my lord, my lord.
You have not read.
This court, my lord, I have read, my lord, but I have interpreted.
Huh?
I have thought.
You have allowed drafting by another. Huh?
My lord, I have thought in different way, my lord.
Well, it cannot be.
Yes,
Your right is limited, made limited because you were a respondent there.
my lord. Yes,
Take try to have this order also.
Yeah.
But this cannot be maintained.
then my lord may take up on some, I will try.
No, I'll close. Will not keep it
Yes, ma'am.
closed. This is clear. Firstly, one issue was there was no arbitrage.
Yes, my lord. My
As
lord.
a result, everything got delayed,
Yes, my lord.
right?
Yes, my lord.
So I'm giving you an order, whether it will be of help or not, you find out.
Already, my lord, already there was, my lord, the order, my lord, for making it a measurement, my lord, by this honorable court division bench, and this ultimately upheld, my lord, by this.
No, Mr.
Yeah.
Along.
Yes.
It is loud and clear.
Yes, Islam is clear, my lord.
You have to prefer
Repetition.
avail appropriate remedy. You have to avail appropriate remedy because tell me, otherwise the law repetition was at the instance of.
Yes, by them, my lord. Yes, by the NHA.
Tell me the law also.
Yeah.
Whether a contempt petition can be at the instance of a respondent. You go through it, you will find out some of help
My lord, my lord.
at your leisure.
Yes, my lord.
Otherwise, I am closing this petition.
My lord,
Heard?
my lord will take up now, man. Or
Yes, I'm
after
closing. I have found it strange because of this. The writ petition was filed by whom?
by the NHA DCL, my lord.
NHIDCL.
Yes, my lord.
Not only NSIDCL,
But yes,
by
my lord.
Union of India.
By Union of India, my lord.
Yes, Mr. Borua, who had the duty to appoint arbitrator. Without appointing the arbitrator, they have filed a writ.
They have.
Where the law is otherwise. I have found it strange.
Petitioner was the respondent in initial
Yes.
petition. So he doesn't.
He was the landowner.
I am the landowner,
Yes.
my lord. My
He has become the respondent.
yes.
Union of India and I think NHIDCL
NHIDCL.
or whatever.
Page 16, my lord.
NHIDCL.
Yes, my lord.
They became the writ petition.
Ah.
They did not appoint the arbitrator
Hmm.
under section 3G5. And they have prepared a writ petition.
My lord, the appointment of the arbitrator has to be done by the Ministry of, my lord. Yes. NHA
Oh,
DCL
it's the
is a-
same ministry.
Same ministry, my lord. Is they are
And
they
you
are,
have
they are
you
execution
have not
agency.
taken the objection then.
Now he's coming.
Contempt will not lie. Supreme Court has said, and I have disposed of also
Yes,
that
yes.
if appeal is preferred, I don't know, against that direction.
Yes, my lord. Yes.
Because if the central government does not appoint an arbitrator,
Yes, my lord.
then mandamus will lie.
Yes, my lord. But yes,
With a direction to the central government, appoint arbitrator within 30 days or 45 days
yes, my lord.
for completion of the proceeding.
Okay.
Now, some confusion arose because of the abolition of the commissioner,
Yes, my lord.
right?
Yes, my lord.
Revenue department, general administration department, all this confusion. So in such situation, I have disposed of that writ petition, 3 writ petitions.
But recently, my lord, this notification has already been, my lord, has been given, but appointment has not been done, my lord. By the
That is
council.
what I had
Yes,
notification regarding revenue.
revenue, my lord. Yes,
That
but
cannot be.
appointment has to be by the central government. My lord. That has not been done yet, my lord.
Heard Mr. G. Alam, direct counsel for the petitioner. So, the petitioner has preferred the instant petition, styled as a contempt petition under Article 26, alleging non-compliance of the directions made in an order dated 16/10/2023, passed in writ petition WBC number 5709/2023. Full stop. It is noticed that in the said writ petition, WBC number 5709/2023, the petitioner was impleaded as party respondent number
10, my lord.
10. Full stop. It is also relevant to quote the following observations made in the order dated 16/10/2023 Supra. Page 21. Thus, it is evident from the order dated 16/10/2023, the petitioner, if the petitioner, as the landowner, continues to feel aggrieved in the matter, then the petitioner has to approach, petitioner has been granted the liberty to approach this court by filing appropriate writ petition. Full stop. Instead of preferring a writ petition in compliance with the direction made in the order dated 16/10/2023, the petitioner has preferred a petition styled as contempt petition. Full stop. In the above view of the matter, the contempt petition, the instant petition is found is not entertained. Full stop. Liberty, however, stands reserved to the petitioner to approach to file appropriate writ petition, if so advised.
Similar.
May
5
I,
and 6, my lord, similar, my lord.
Similar.
Yes, my lord, 5 and 6.
Okay, who is she is respond number
Yes, one number, this was 10, my lord.
10.
Yes.
Different
Yeah,
repetition.
Divine writ petition,
Okay,
my lord.
different repetition. Number 2. Repetition number 2, 5712/2023.
Yes, my lord.
Order date same.
Same,
Order
same.
is date same. And observation,
Same, my lord.
observation 21 also high level, same. And respond number
Respond number 10, my lord.
10.
may I, your lordship,
In item number,
yes, on 15th of December 2023, your lordship, the appointment of arbitrator for land acquisition has already been done. One Mr. Ashok Kumar Burman, IS retired. He has been appointed as the arbitrator for land acquisition matters, your lordship.
that direction in
Yes,
the
I have the-
three petitions were disposed of,
Yes.
directing the central government
Yes.
in
Yes,
consultation with the state government to appoint the arbitrator within so many days.
Thereafter, this
Okay.
this was issued, your lordship.
Now you
Now-
can
now-
take
now-
every defense before the
arbitrator.
This has been issued by the Principal Secretary Revenue Department to the Under Secretary Ministry of Road Transport and Highways, Transport Bhavan, New Delhi.
central government.
Madam.
So that
That.
I have given a copy of
Yes,
the
my lord.
order.
Yes, my lord.
I think that is complied with. Take a copy of,
Yes, that order also.
and if still you are aggrieved, you file
Yes,
it.
we get it, my lord.
Z Alam, same
Six-
thing.
Same thing, my lord. Yeah, respondent, my lord, is 10, 11, 12, my lord.
10, 11, 12, applicable. WBC number 5708/2023. Observation to semi after
Same.
file of page 22. And order dated same.
Same.
Order date same.
Oblige, my lord.
Yes, madam.
My lord, the petitioners are the job card holders, my lord, who have completed the work, my lord, flood protection bulb, my lord.
Okay.
My lord,
You are MS
and Nasrin, my lord,
and Nasreen.
my,
Yes, Mr. Dotto.
My lord, at this stage, notice may go, my lord. Otherwise, my lord, if petitioners were job card holders,
Ah.
the bill is 14,27,238, my lord. For job card holders, such kind of bill, my lord. And they are also saying that some involvement with some tractor and all, my lord.
Ah.
So whether they are registered contractor or not, that has to be examined, my lord. Job card holders cannot use tractor for supply of earth, my lord.
Own labor.
My lord. Only labor, my lord. And
Yes,
it's
what is your story?
5 petitioners filed together, my lord. Different cause of action, my lord.
Hard.
Paragraph number 2, my lord. Lordship, I kindly read. Non-payment of artwork in incumbent by the tractor.
Job card, non-payment of wages of the job card holders. Okay.
Yes. And petition number 3 is the agreed by the non-payment of artwork.
Ah, two cause of action you have clubbed together.
Yes.
One is contractor. We
Yes.
are not interested with the contractor
my lord, petition,
unless it is admitted.
my lord, petition number 3 is the tractor holder, my lord, who has.
We are not interested in a contract. If you are job card holder, definitely you are a person who should be given importance. And contractor whose bill is not admitted, he is to be relegated to other forum. You cannot make two. At least this code does not entertain. If you want to try your luck, I think this code will not entertain clubbing of cause of action.
My lord, nobody there. is-
This code wants to
my
be
lord.
strict in this particular matter.
My lord, nobody contractor, my lord.
Yes, 3, paragraph 3. 2.
Two, my lord.
Clear. 1, 2, 4, and 5. They are job card holders. No doubt. You have made a statement. But petition number 3,
Owner of the tractor, my lord.
he is a contractor, madam. You cannot club a contractor with job card holders. A job card holder in a year gets how much? Maximum.
My lord. The amount.
Maximum maybe
Yes, my lord.
50,000
Not 50,000 less.
in a year, say.
Oh, yes, my lord.
Or
My lord.
job card holders.
My
So
lord.
2 lakh.
Maximum.
Let us take, for the sake of argument, 1 lakh per year.
Yes.
4 lakh.
4 lakh.
Then the balance 10 lakh.
Yes, my lord.
You are claiming 14 lakhs. Take your call, otherwise we are passing order.
My lord, I may be withdraw the petition with liberty, my lord.
Don't club job card holders with a contract. Contractor is a person who is an owner of a dumper tractor. And these are BPL, below poverty line or something like that. MS and Nasreen Learned Council for the petitioners have submitted that since there is clubbing of cause of actions with the petition number 1, 2, 4, and 5 on one hand as job card holders, and the petition number 3 as a tractor owner on the other hand. The petitioners want to withdraw the writ petition with the liberty to file press writ petitions. Mr. Dr. Standing Council, Panchayat and Rural Development Department. As Dr. Anybody else?
I am for respondent number 3.
1,
I'm
2,
2, 4, 5,
5,
6, 7, and 9.
6, 7, and 9. And MS Boro.
I am for three.
Junior Government Advocate Assam for the respondent number 3, who have objected as the, to the objected on the maintainability of the writ petition, have agreed to the prayer made by the learned counsel for the petitioner. Full stop. In view of the above submission made by MS Nasri, learned counsel for the petitioner, the writ petition is dismissed on withdrawal, with the liberty as briefed for.
Item number 9.
Obliged.
May it please. Yeah, that's forest really last at us. Oh, this one.
Yes.
Royalty.
Lords.
You are a builder or you are
Lords.
builder?
Builder.
Assam real estate
Covered.
covered.
Yes.
Will pass similar order only.
No.
No change will be made. Page 41. Will not make the labor. Heard, Mr.
A. Sharma.
A. Sharma, learned counsel for the petitioner. Mr. Bora, you present Chief Secretary also?
No, IPR for.
S. Borua, learned Junior Government Advocate Assam for the respondent number 1, Mr. I. Botagur, learned counsel representing Mr. P. N. Goswami, learned standing counsel, Environment and Forest Department for the respondent number
2 and 3.
2 and 3. Mr. S. Bora. Oh, Mr. Borua will be also for 5, 6, 5 and 6. Mr. S. Bora, learned standing counsel, Housing and Urban Affairs Department, ZMC and ZMDA for the respondent number
4, 7, 8, and 9.
4, 7, 8, and 9. Full stop. Whereas page 41. The learned Mr. So-and-so learned counsel for the petitioner is submitted that the issue raised in this, involved in this petition is similar to another petition, WBC number 2040 2023, within bracket Assam Real Estate and Infrastructure Development Corporation versus the state of Assam and 6 others. So he has further submitted that the petitioner is also petition is also similarly situated to be granted the interim relief, as granted by the order dated 12/4/2023, passed in WBC number 2040/2023. So the learned counsel paying for the petitioner have submitted that they, at this stage, would not raise any objection regarding grant of similar interim relief. Page 41. Number change issue notice returnable 4 weeks থাকিব last নালাগে আৰু তাৰ আগতে লিখিব এইখিনি আগত ফাৰ্ষ্ট পেয়াৰ আগত ফাৰ্ষ্ট পেয়াৰৰ পিছত মাজত এটা the petitioner, who is stated to be a builder stroke developer, applied for no objection certificate for construction of a residential building over a plot of land measuring 2 kathas 10 lessons covered by paragraph 2 AP Patra number 938, and DAG number 2363, Situate at Revenue Village, Betkosi, Mauza, Beltola, District Kamrup, and Rosa. After submission of the application online with a deposit of the requisite fees, the petitioner has stated, petitioner has deposited labor cess at 1% on 22/10/2023. The petitioner has approached this court by this writ petition with the grievance that the NOC has not been issued on the premise that the petitioner has not deposited 2% royalty on the total cost of the building for which the NOC stroke permission has been applied, right? Page 41, 42, deeply.
Number 10.
Next, please, Lordship. Lordship, here what happened, my lord, here order was passed on 12/5/21, order in original, my lord.
12/5/21. Where is that?
Page 63, my lord.
Page
63. Thereafter, my
order in original.
my lord.
Okay.
Thereafter, my lord, appeal was preferred. It was preferred on, my lord.
Order in 61.
My lord,
Where is the order in original?
63, my lord.
This is the date.
My lord.
Date.
Date, my lord, in last page, my lord. Page
Tell me.
69, my lord.
Huh?
69.
Date.
Date is in 69, my lord.
Date is in 69. What is the date?
Sorry, my lord. 12/5/21. Sorry. 12/5/21.
Okay.
Appeal was preferred on 17/6/22, my lord.
Appeal.
Preferred on 17/6/22, my lord.
1 minute. Appeal 17.
6/22, my lord.
17/6/20. Yes.
Appeal was dismissed on 14/9/23, my lord.
Order in appeal.
Appeal, my lord, page 96, it was dismissed. 96, my lord.
This is 49.
My lord, 14/9/23, my lord. It was dismissed as time barred, my lord.
Order in appeal 14/9/2023. Where is the observation?
My lord, page 103, my lord. Last page.
It is basically 2 months or 60 days. Appeal
2 months plus 1 month, my lord.
plus 1 month.
But here,
March, April, May. Your appeal is in June.
my lord.
Appears to be game over.
No, my lord, the case is different, my lord. Since the limitation was expired within the COVID period, my lord. After, my lord, from 1st of March, my lord, everybody having the limitation of 90 days, my lord. It is, it says, ma'am, I'm
We
relying.
take also, if we take this, Where is that judgment, Supreme
Page
Court?
85, my lord.
Page 85.
85. It starts from 83, my lord. 82, starts from 82, my lord.
85, yes.
My lord.
Even, let us take 3, Roman 3.
My lord,
It is 90 days.
my lord.
If we take also Roman 4, that is Finance Act,
My lord.
section 85,
3A, my lord.
85 3A. Then also 90 days.
That's why I'm relying upon Roman 3, my lord. What I'm saying, my lord, till 90 days, my lord, I have a limitation, my lord. Thereafter, my lord, the commissioner will exercise his own jurisdiction.
That cannot be.
But 85, lordship
That
will-
cannot be an interpretation.
no, lordship will
Okay, when is the other case regarding that 60 days plus appeal
Yes,
was
sir.
filed within 30 days?
Lordship has issue notice.
notice,
Ah.
my
Lordship may take with.
Both the take, we will take a call
my lord.
on the date. When?
Date has not been, it
The
is,
hearing date we have fixed.
I'll just check up. I'll provide date, my lord.
What is the case number?
I'm providing.
I'll provide them.
Heard Mr. R.S. Mishra, learned counsel for the petition. But here we don't fill any course interim order.
My lord, otherwise it will be recovered, my lord. My tax will be recovered, my lord.
If they start, then you come. Then we have found a privacy case there,
My lord. No, here,
but we have not found any privacy case here.
my lord, my submission is this, my lord. Power to exercise condemnation will come
Tell
after
me
expiry,
one more issue.
my lord.
Suppose an appeal was prepared
My lord.
with an application for condonation of delay.
My lord.
1 minute. Let me complete.
Sorry, my lord. Extremely sorry.
And while taking the appeal, the appellate authority has also taken up the application for condonation of delay. Then finding no sufficient ground or not legally maintainable, the application for, you have filed an application for delay also.
My lord.
The application for condonation of delay is dismissed.
My lord.
So basically, he did not enter into the merits of the appeal. So what will be the legal consequence? That order for dismissal of the application for condonation of delay and consequent dismissal of the appeal, both will merge or will lie separately? I'm asking you this question because of the fact that if both merges, if both the order merge, then there is a provision for appeal before the start.
My lord.
In one judgment of Honorable Supreme Court in case of second appeal, this
That is why I am asking him,
But this, I have gone through one
because there, if that is so, then there is a statutory alternative, efficacious and adequate remedy.
Yes, my lord.
Right. That is the issue only to be examined.
I have gone through one judgment of Sestet, my lord. In similar case, my lord.
Sesta will not do.
After my lord.
Sesta is not binding on us.
in second
Then in
appeal
one of the High Court also, my lord,
Sesta is not binding on us, Mr. Mishra.
the Gujarat High
Don't
Court,
fight.
Gujarat High Court has also, my lord,
That may have a persuasive value.
full bench is judgment is
There
there.
is a judgment.
Come up with Supreme Court.
Lordship may
Lordship,
take up
there is-
after tomorrow.
There is a judgment of Supreme Court in case of second appeal. When the first appeal was dismissed on the ground of delay, then we preferred revision. Then Supreme Court said no. You have to complete the appeal, challenging the original order. That judge
And
is
if
right.
that merges, if this order, page 103,
My lord.
means merging of the appeal with this order, then section 86,
That is,
that is the issue only to be examined.
I'll place that judgment.
Yes. Have you got it now?
my lord.
Your case is very confined. All right, Mr. R.S. Mishra, and Counsel for the petitioner? Any union? MS, yes, Guru. She has to accept, Mr. Kyle?
Yes, he can accept on behalf of.
Lawrence Central Government Council for the respondent one. Yes, what do you say? No idea. No idea. Mr. S.C. Kyle. Lawrence Standing Council GST for the respondent number 224. Full stop. The petitioner was served a show cause notice. Where is that?
Page 63, page 60, my lord.
Under section 73.
My lord.
Demand come show cause notice.
My lord.
On 23/10/2019. Under section 73, I think within bracket 1,
Yes, my lord.
1 of the Finance Act 1994.
94.
To show cause as to why service tax amounting to rupees 31,21,521 plus italics or zero plus italics or zero interest, penalty, etc. should not be imposed upon him. Full stop. The order in original was thereafter passed on 12/5/2021. Full stop. The petitioner had preferred an appeal under section 85
My lord.
within bracket 3A of the Finance Act before the appellate authority on 17/6/2022. On the basis of the order dated 10/1/2022 of the Honorable Supreme Court of India in page 82 in re cognizance for extension of limitation. So as along with the appeal, the petitioner filed an application for condonation of delay. Full stop. The appellate authority, that is the commissioner within bracket appeals, CGST, Central Excise and Customs, had passed the order appeal on 14/9/2023, holding that the appeal was filed after 17 days, 17, beyond the period of limitation. Full stop. Agreed by the dismissal of the appeal, rejection of the appeal as time barred, the petitioner has preferred the instant writ petition. Full stop.
WPC number 7208/23, my lord.
Lovely. Issue notice. Returnable on dash idea. As MS Borwa has appeared CGC has appeared and accepted notice on behalf of the respondent number 1, and Mr. Kyle understanding of the GST has appeared and accepted notice on behalf of the respondent number 2 to 4. No formal notice needs to be issued. The Mr. Mitchell and counsel for petition shall, however, furnish a requisite number of expert copies of the writ petition on the within 3 working days from today. Place the case on
13-2.
13.
Some protection, if lordship, some protection.
Don't take. Will side.
Probably department will not take any action.
Some observation, my lord, otherwise apprehension, my lord.
No apprehension. It will come with an eye.
Much
If required, we will protect you.
Always, your lord.
Because for protection, we have to be satisfied prima facie.
Lordship. Item number 11.
May it please, your lord.
Hmm.
Lord, on 17/10/2021, petitioner's mother was killed in a road accident near Rukmini Gaon while going to church to perform her Sunday prayers.
Heard Mr. M.K. Das, Florida petitioner.
In fact, here revenue is also an associate party. It hasn't been made here. Ultimately, the verification has to be done by the revenue department.
Mr. Das, then you file an amended memo as per the if revenue is to be, because the notification is of the revenue.
Revenue.
Ex gratia.
Ex gratia.
Then that notification is of the revenue and disaster management department.
Okay, my lord.
That has to be made a party because we are directing the revenue secretary to disburse the amount in all the retribution
My lord.
by every court.
I'll file an IA, my lord.
IA, you file an IA,
My lord.
we'll keep it pending.
My lord.
When you are expected to file.
My lord, tomorrow I'll file.
Okay. Friday?
My lordship.
Okay. On the prayer of Mr. M. K. Das, Learned Counsel for the petitioner, lays the case on Friday. Friday is, I think, 26 Republic Day.
My lord, on reopening
Okay.
26, 27, 20,
29.
Deeply obliged.
Number 12.
So here in this case, lordship, the petitioner is running a private cattle market on his private land, lordship. The respondent, official respondent by a purported order that is 34, lordship, cancelled the NOC issued to the petitioner.
1 minute.
Easy way, you know. It's 34.
Lordship, no focus notice has been issued, and in this letter, lordship, no.
No, you are Amjad Ali Mandal. I have
Yes.
checked Amjad Mandal.
Yes,
You-
lordship.
Amjad Mandal and Amjad Ali Mandal is
Yes.
same.
Same person, lordship.
Then what Sokos? You have appeared. You have appeared before him.
There is, they have allegation that, lordship, we don't have that land is disputed. I have
No,
taxed
no.
the land.
Your name, where is the following? Where is the following instructions? So and so has heard Amjad Ali Mandal.
That is for lordship.
So it is not a clear violation of principle of nature.
I was not-
You have been heard
No, lordship.
and
Lordship.
recorded that you could not show any valid document.
Now-
So principle of natural
Yes.
justice is to be considered on the basis of the case.
Now,
Case on
lordship,
record.
lordship, kindly see, lordship, the order by which the.
So what document you have annexed?
Lordship, kindly see land document, lordship.
Tell me, which
Uh,
one?
Page 19, this is my dolil. It is start page 18. I have given the type copy, Lordship. It starts from page 15, Lordship. Sorry. My
Huh?
father, Abdul Mandan Mondal, he purchased this land, Lordship. Page 15, Lordship. And type copy is page 14, Lordship. And I have paid the revenue receipt till 2020. Thereafter, they have not receiving the amount, Lordship. My father expired, and that is why.
Oh, the case is a disputed one. Let us
No,
take
Lordship,
them.
no, Lordship. It is a clear cut. Lordship, kindly see. In input order, they have said that the by order dated 26/23, by which the.
No, Mr. Ahmed,
Lordship.
there is also a report.
That is a Lordship. I'm coming to that, Lordship. That is false, Lordship. There is no land in the land in the name of the Chataimari Bazar, Lordship. The cycle
No,
officer report is there,
No,
Lordship.
no. Paragraph B, there is a report of the revenue circle officer. Right.
Yes,
That
Lordship.
the market has been running in a government plot of land.
No, Lordship. The report is there, Lordship. Kindly see. Page 26, Lordship. 26. This is a letter issued by the Lat Mandal to the addressing the revenue cycle officer. Here, Lordship, one RT application was filed.
26.
26, Lordship. Type copy.
Whose
One
cycle?
Humayun Ali filed RT application wherein the Lat Mandal and the cycle reported, Lordship.
Huh?
One
Page
RT application filed by which.
26.
Case 26. Annexure 6. Case 26.
Humayun Ali, Azmat Ali.
Has sought information relating to the land of Chata. This should be Chatai Mari, Lordship. Typing Chatai Bari. It is written Chatai Mari, Lordship. My type. I have mistake. As per record, there is no land in the name of Chatai.
Oh, that is Lat Mandal.
Cycle officer endorsed, Lordship. Kindly see next page, Lordship. Cycle officer.
He has simply,
No, Lordship. Here,
without blinking the eyes, he has signed it.
Lordship, kindly see cycle officer endorsed in page 27, Lordship. As I have mentioned.
No, we'll have to issue notice.
No, Lordship, only 1 minute, Lordship. I'm satisfied, Lordship. Lordship, kindly see the by which the respondent number 8 was settled, page 28. The order dated 26/23. I'm coming to that, Lordship. 26,
Page?
page 28. Page 28. This order has been passed by the CO and settled the hard Lordship with the private respondent. That was challenged by in a title suit, Lordship. That was status quo order has been operating, Lordship. Bypassing the order, they have issued this order, Lordship. The court's order is there, Lordship. Page 28, 29, Lordship. Challenging this order dated 26/6/23 at page 28. I have filed this title suit. Where status quo order is there? Order dated 19/7/23, page 29, Lordship. Page 29. I have filed a title suit, Lordship. And page 33 is the operating part, Lordship. Page para 13. In spite of knowing this fact, Lordship, the status quo order by the title in the title suit order, Lordship, I have filed where status quo order is operating. Then knowing the fact they have this order decision only to for the vested interest, Lordship, in favor of private respondent, Lordship. And still I am running the market. And Lordship, only the Gaubura also, he is a government officer, Lordship, appointed. He is also page 36. He is also given a certificate, Lordship. Kindly see. Page 36 is a certificate issued by Gaubura. Still I am running the market in my own main, Lordship. Page 36. Order 9/1/24, page 36. This is to certified that Chataimari Poshuhat is running at the private land of Amjad Mondal, son so-and-so, Gumaisar Lokhimitri Golpa, Assam, Lordship. I'm running. This is not disputed. Only purportedly, only favoring this.
No, by the impugn order, whether he has been this man,
Yes, respond wait.
has been allowed to run.
Lordship, line can
Has been-
came and disturbed me. I have filed a page 37. I have filed an.
Mr. Ahmed,
Yes.
whether there is any specific direction that Ajibur Rahman has been allowed to run the market.
There's no order, Lordship. That is my
Then,
Lordship.
if he has violated, then you have to approach the
Civil code.
civil code.
There
If
is
he
a
has
Lordship.
violated, because this order does not indicate that Mr. Ajibur Rahman has been allowed to operate the market.
Yes, that's
And
true.
you have filed a writ petition, obtain a status quo order,
Yes,
right?
yes.
Then order 39/12, right? Let
Only
us see.
disturbing, Lordship.
No, let us see
Yes.
the provision.
I have made
Let
the.
us see the provision.
Yes.
Order 39, rule 1 and 2.
Last occasion or last.
Last occasion, we'll see. Let us
Yes.
see the provision first.
Yes, Lordship.
Order 39. Rule 1. Then Rule 2A. Consequence of disobedience or breach of injunction. For that, if Ajibur Rahman or the other parties have breached the injunction order,
Yes.
remedy lies in Rule 2A.
Yes, Lordship.
Right?
Yes,
We
Lordship.
can issue only notice.
Lordship, some observation given, Lordship.
No
Lordship,
objection.
kindly see page
We do not run parallel administration.
page-
Civil court is in season of the matter, and you are the plaintiff yourself.
Yes, Lordship.
We can close this petition right now, but we are keeping it.
On Lordship, I am running the market, no, there is no issue.
That
But
we
last
are not
location
determining, Mr.
came, I have filed it.
May I submit, my lord? Lordship, page 34, impugn order, once again may be seen, my lord. After the enquiry, my lord, and hearing the parties. Number 2, point B. One Azibur Rahman has been settled the same market by Gwalpara Zilla Parishad, wide order dated so and so. And the market has been running at a government plot of land.
That is what I have already
Yes, yes, yes.
indicated.
And that Azibur Rahman filed one case, my lord, which is pending today, my lord, listed today, my lord, in a different court, my lord. So
And-
that both cases may be heard together, my lord.
We
But Lordship-
cannot take.
But the no NOC
You
which.
get it
was issued to
listed, we
Yes,
can
yes,
issue.
yes. On the next date,
You
my
take a date.
my lord, my lord,
Lordship, please, the
mention a
NOC,
date.
Lordship, only thing is that
Make it
Lordship,
returnable.
my lord.
Okay.
It will take some other, not yet listed.
Notice.
Notice may be issued in this matter, and the matter may be tagged with that or without any date, maybe.
but my only problem is, Lordship, the NOC which was issued to me for running the market, that is revoked by this impugned order, Lordship.
Huh?
The NOC which was issued to run the market, that has been revoked by this.
We'll
impugned order.
examine that.
Yes.
So status at least, Lordship, for notice.
Status quo over status quo, we are not passing.
Already,
Mister-
already cancelled, my lord.
Then I am relegating you to the civil court
Can cancel.
to avail remedy under Rule 2A, Order 39, CPC.
Otherwise, this case is not maintainable. my lord.
Otherwise, I am not finding, that is why I am saying that we will keep it pending
My lord.
till the returnable date. Because there is no express order
Yes.
that Ajibur Rahman has been allowed to run the market. So the status quo order is not violated. If you think that it is violated, remedy for you is under Rule 2A, Order 39. We can only examine this order.
Yes, sir.
Says 34. Heard, Mr. Yes, you are made learning counsel for the petitioner. As Dr. Punara standing counsel, Panchayat and Rural Development Department for the response of 1, 2.
1, 2, 3,
Mhm.
6. Oh, yes, and
Okay.
6.
Mr. S. Borua, Lara Junior Government Advocate Assam for the response number 4, 5, 7. No stop. Sale is made to an order dated 30/12/2023. Annexer 9. Passed by the respondent number 4. Whereby the operation of Chataibari Pupuhat run by the Chataibari Chatai Mari
Yes.
Pupuhat Bazar Committee has been suspended with immediate effect, and the NOC granted to it earlier, has been revoked on the purported ground of not obeying the conditions. Mr. Amit, Learning Counsel for the petition, has submitted that the committee, Bazar Committee, has been running the market on a private plot of land, and the same is can be evident from Annexer 1 registered sale deed. Close the. Mr. Dr. Standing Council. Honor Panchayat and Rural Development Department and Mr. Borua and State Council have submitted that after it was after an inquiry, comma, as reflected in the interim order dated 30/12/2023, comma, it is found that the plot of land, the ownership of the plot of land is a disputed one. So they have further submitted that a title suit has already been instituted by the petitioner as the plaintiff. Before the court of civil judge, land is civil judge Valpara. And the form of a title suit, comma, title suit number 82/2023. Who is Amjad Molla?
This is plaintiff lordship. This is Amjad.
Yes, different name. Amjad Ali Mondal,
Yes,
Amjad
lordship.
Molla, and Amjad
It should be Amjad.
Amjad Mondal. 3 names. And in an application numbered as registered as Miss J case number 30/2022. Preferred under order 39, rule 1, CPC, comma, an order of to maintain status quo has been passed on 19/7/2022. By submitting so, the counsel for the respondent have also raised the issue of maintainability of the petition. Issue notice returnable on 19/2/2023 as so and so appeared accepted. The petitioner shall take steps for service of notice upon the respondent number 8 by registered post with AD within 3 working days. The issue of maintainability is left open for consideration on return.
Matter may be tracked with WBC 7496/2022.
List this repetition along with
WBC number 7496.
repeat along with WBC number so and so
7496/2023.
stated to be which according to the current counsel for the petitioners, comma, involved common issues.
Mayor, I pray before your lordship, this matter may be taken at 2 p.m. because my lord, Mr. MSA will lead this case. Masu.
14.
So this is a petition, my lord, under 226 against the, my lord, judgment passed by Board of Revenue. Appeal was, my lord, dismissed.
Board of Revenue.
Yes. Basically, my lord, on the ground of delay. They said that, my lord, since there is a lapse on my part in not making explanation, day-to-day explanation.
Okay, we will issue notice at this stage. Okay. Yes, Mr. We are admitting the repetition.
My lord.
Where is the order?
Order is, my lord, at page 135.
135.
Ten 2023.
Where is that observation, that delay?
Delay is, my lord, lordship, only, my lord, at page 137.
B.
B and C. 10A, B, C. All the 3 paragraphs relates to delay.
Okay.
the applicants have failed to provide a convincing justification for delay in filing their deed within stipulated time. No comprehensive account of day-to-day explanation.
This is review order or what?
No, it's a writ petition.
No, this is review order or
No, appeal.
appeal? Heard Mr. A.K. Procaster. Now, counsel for the petition. Petitioners. Any revenue? Mr. M.S. Z. Hazarika. Is pending also revenue and disaster management department for the respond number 1. Mr. S. Borua. 10 and 11. Learned Junior Government Advocate Assam for the respond number 10 and 11. Full stop. The repetition is prepared against the judgment and order dated 10/10/2023 passed by the learned Assam Board of Revenue in an appeal preferred under section 147 of the Assam Land and Revenue Regulation 1886, comma, appeal number 8RA within bracket HO bracket close Bojai stroke 2023. Whereby the appeal has been dismissed on the ground of delay. Late rule be issued. Issue notice to the respondents as Mr. So-and-so, Bordele and so appeared, accepted no formal notice. The petitioner shall take steps for LCRB call for, huh?
Yes, my lord, also kindly suspend the, my lord, impugn order. Because it will have a political effect in the pending case of the, my lord, pending civil suit. Because, my lord, entire records were held to be fraud, forced, fake, fraudulent. And on the basis of that, my mediation was cancelled.
Then we'll issue notice on a returnable date then.
As your lord. She may issue rule and, my lord, issue notice on, my lord, interim pair for stay, and by that time,
Okay.
returnable.
Issue notice, let rule is issued. Notice, issue notice to the notices will be also issued to the respondents as so-and-so appeared, accepted, no formal notice, extra copies. A petition shall take state for service of notice by registered post with AD upon the respondent number 229 by registered post with AD within 3 working days. Notice LCR call for LCR of so-and-so, huh?
Yes.
We call for. Notice is also issued on the prayer for interim relief. Lays the case on 26/2.
Till that time, my lord, some.
No, what will happen? What is the?
Because suit is pending, my lord, and they said, my lord, my mediation was cancelled. Oh, my lord, by in view of these findings, my lord, court may take an adverse view.
Who?
Trial court, civil court. Then obviously they will take the advantage of this judgment. Initially, my lord, land was the government land. It was ultimately
Notice is
settled.
issued and returnable on 16/2. Oh, sorry. Release the case on 16/2. We'll consider that prayer. notice is issued. Because the appeal has been dismissed on the ground of delay.
My lord. That's why, my lord. If merit was
That
not,
is why.
merit was not even touched.
It was not even touched.
My lord.
That is why. 16-2.
And LCR was called for, my lord. Obliged.
Item 16.
May it please your lordship. In this case, the petitioners before lordship are elected members of the Gaon Panchayat as well as the villagers.
Elected member of Gaon
Gaon Panchayat as well as the villagers, my lord. They have
Villagers. Why they together?
What happened, some schemes under the 15 plan, financial commission plan has been sanctioned by the authority without placing the schemes in the Gaon Sabha. Requirement is it should be passed by the Gaon Sabha. Thereafter only question of sanction is comes. But it without sanction, passing the schemes under by the Gaon Sabha, they have sanctioned the schemes at the behest of the president. And the president has constructed a construction committee of his own without placing the matter at the Gaon Sabha. And trying to mismanage the misappropriate the.
How the basically your grievance is construction committee.
No, my lord. We are against the sanction as well as the construction committee, because sanction is also not as per the guideline. Guideline also you will find at page 14. Guideline says it should be passed in the Gaon Sabha.
So the provisions contained in this notification have not been complied with.
My lord.
That is your case.
My lord, that is my case.
Selection of scheme.
My lord.
Okay, selection of scheme.
It should be fifth line, my lord, are to be approved by in Gaon Sabhas. It has not been approved. The villagers as well as the petitioner members, my lord. My lord.
Gaon Sabha. Okay. That is what?
That is one, my lord.
And
the other is, my lord, implementation and monitoring the scheme, my lord, page 21. My lord, last column, my lord, block level advisory monitoring committee shall scrutinize the schemes selected for annual plans, keeping in consonance with the following: whether the schemes in the GPDP are as per approved scheme in the Gaon Sabhas or not. In case schemes are not approved by Gaon Sabha, the committee shall arrange inclusion of schemes approved in Gaon Sabha. So without approval of the Gaon Sabha, my lord, schemes cannot be.
but if the block level advisory monitoring committee approves, then Gaon Sabha's approval is not required. That is the reading. Whether the schemes in the GPDP are as per approved schemes in the Gaon Sabha or not.
My lord.
In case the schemes are not approved by Gaon Sabha,
my lord,
the committee shall arrange inclusion of the schemes approved.
Yes.
Okay.
Without Gaon Sabha approval, my lord, schemes cannot be sanctioned.
Now what is, have you represented?
Yes, my lord. We have filed representation. The page 36 is the representation by the villagers.
Villagers.
My lord. And page 38 is the representation by the 4 members, including the vice president.
Now, agreed by non-disposal by representative have come.
No, my lord. My lord, they are contemplating to implement the scheme without approval of the Gaon Sabha. That is why they have come, my lord. The public money, my lord, that should not be misutilized, my lord.
Let him take a call then, chief executive officer.
My lord, till then, my lord, the
No.
may not be
Either this way or that way. If file representations, these petitioners
My lord.
complain before the chief executive officer, let him dispose of this after consideration of the ground situation.
Yes,
If you are still aggrieved, then you come.
my lord, that can be done, but my lord, till the disposal, the scheme
No,
may not
no,
be
why
implemented.
development scheme should be stalled?
My lord, because the development
No, no,
schemes are, my lord,
development
the
scheme should not be
sanction-
stalled unless it is illegal. Let him find out.
my lord, it is.
Let him cause an
illegal, my
inquiry.
lord, because my lord, it has not been passed by the Gram Sabha.
Let him
Yes.
cause an inquiry whether it is scheme passed by.
My lord, if
Gram Sabha.
tomorrow, my lord, if my lord, schemes are implemented,
We are not staying then. We'll only issue. Development schemes, we don't know.
my lord, development schemes, it is should. it
Let
should
him
be meant for
examine this,
development.
whether these Gram Sabha or Gaon Panchayat have proceeded strictly in terms of the procedure laid down in the notification as regards selection of scheme, approval by the Gram Sabha, and construction of committees.
My lord.
Then by causing an inquiry on the basis of the representation
My lord.
and pass a speaking order.
If that is not followed, my lord, the schemes can be, my lord, placed before the Gaon Sabha for, my lord, approval, my lord. The before implementation, if the formalities are not, my lord, followed as per the guideline.
If he passes a speaking order, then that is enough.
My apprehension is that.
Causing an inquiry, after causing an inquiry, let him cause an inquiry. We are not here.
Apprehending,
as
my
a
lord.
fact-finding authority.
Public money should not be go to the wrong hand. It should
Right.
be implemented for
But at the same time,
development of the public.
just because on the basis of environments, we should not also stall public projects.
Yes, that is true, but my lord, they have not followed. It has been, my lord, brought to the.
You have made the
light.
allegation.
Yes.
If we issue notice at this stage, stalling some public projects, at a later point of time, it
Notice
is
may be issued,
found.
my lord. Short notice may be issued, my lord. My friend may take his instruction, my lord.
We'll go by then NG projects. If submit and guarantee. Development projects should not be stalled at the instance of few villagers and few ward members.
My lord, the representation filed by the villagers
let-
are, my lord.
Hard,
like
Mr.
it-
No, no.
Long
Lordship, may I dispose of the matter,
representation
my lord?
Let him cause an inquiry.
Yes, ma'am.
If there is, if he finds violation of the procedure prescribed in so and so, remedial measures should be directed by passing a speaking order. If the petitioners are still aggrieved, it will be open for the petitioner,
My lord.
right? Let us have a clear picture. Here it is in the form of allegation now.
Yes.
Heard Mr. I.H.
But what happened, my lord, the president, he has managed, my lord, 6 members. There are 10 members in the, my lord, committee.
The board is aware of all this situation, but since this cannot be
Yes.
reflected in the order, so we are not reflecting it in order.
My lord.
These are happening.
Yes, my lord.
S. Dotto, Learned Standing Council, Panchayat and Rural Development Department for the response number
1, 2, 3, and 5.
full stop. The petitioners, comma, any number, comma, have joined together to institute the present petition under Article 226 of the Constitution of India, stating that they have a common cause of action to espouse. Full stop. The petitioner number 1 to 4 have stated that they are elected members of 21 number Kochumara Gaon Panchayat, and the petition number 5 to 10 are in evidence of the in evidence within the territorial jurisdiction of 21 number Kochumara Gaon Panchayat for sure. They have stated that they have preferred the instant repetition in representative capacity. Full stop. Para. It has been stated that the state government has allocated an amount of rupees 21,38,000 each towards the first installment and the second installment for the financial year, 2022-2023 for the Gram Panchayat, which is under Senga Development Block. But the said installment amounts have, however, been not yet released in favor of the Gram Panchayat. Para. The petitioners have referred to a notification, page 14 or so, bearing number so and so dated 23/11/2022 of the Panchayat and Rural Development Department to contend that the state government has thereby laid down comprehensive guidelines for implementation of 15 Finance Commission grant in respect of a Gram Panchayat. The petitioners have contended that a Gram Panchayat is required to prepare a cogent development plan in the form of ZPDP within bracket Amar Gaon Amar Asoni bracket close for utilization of 15th Finance Commission grant. Full stop. Any scheme under the 15th FC grant program is to be selected by abiding the ZPDP guidelines, and one of the requirement is that the ZPDP is to be approved by the concerned Gaon Sabha. Full stop. Another contention of the petitioners is that insofar as the contention of the petitioner is that insofar as 21 number Kosumara Gaon Panchayat, the schemes are being prepared by the president of the Gram Panchayat without approval of the concerned Gaon Sabha, right? So the petitioners have further contended that the president and the secretary of 21 number Kochawar Gaon Panchayat in clear disobedience of the guidelines framed by the notification dated so and so have constituted a construction committee by including persons of their choice. Whereas, as per the guidelines, the construction committee are to be constituted how it is to be constituted? In a meeting of a Gram Sabha. Meeting of a Gram Sabha. Full stop. The petitioners have also drawn attention to the provision contained in the notification, which states that the schemes in the ZPDP are to be approved by the Gram Sabha. And in case the schemes are not approved by the Gram Sabha, the block level advisory monitoring committee can only include the schemes, cannot include the schemes, cannot include any scheme which is not approved by the Gram Sabha. Full stop. The petitioners have also alleged that the alleged irregularities have been brought to the notice of the respondent number 2 by submitting 2 representations. That's one dated what is the date? 21/11/2023 by the petition number 1 to 4.
No, my lord.
Page 36.
Page 36 is the, my lord, petition number 5 to
Petition
10.
number 5 to
10 and
10.
other villagers.
And the other dated and the other representation dated 28/11/2023 by the petition number 1 to 4. Full stop. As the said, as the respondent number 2 is found to be according to petitioner's command, the respondent number 2 has not given due consideration to the said 2 representations wherein the alleged irregularities committed by the respondent number committed by the president and the secretary of 21 number Kochumara Gram Panchayat have been brought to light. Agreed by such alleged inaction, the petitioners have preferred the instant petition. Mr. Dr. standing off. Panchayat and Rural Development Department has submitted that since the 2 representations stated to have been submitted by the petitioners and referred above, are pending consideration and as to whether such alleged irregularities were committed or not would require causing of an inquiry, comma, this repetition may be disposed of with a direction to the respondent authorities more particularly the respondent number 2 to take the said two representations on board and thereafter, comma, to dispose of the same by speaking order after ascertaining the veracity of the allegations made by the petitioners in the said two representation. Having considered the submissions of the learned counsel for the parties, comma, this court is of the considered view that this court, in the said two representations, comma, dated 26/11/2023 and 28/11/2023. The petitioners on perusal of the table, it is noticed that the petitioners have already brought have already indicate the alleged irregularities in the implementation of the schemes under in respect of the grant sanction 221 number Kochumargaon Panchayat by way of two installments under the 15th Finance Commission grant for the financial year 2022-2022. As the alleged irregularities indicated therein, as well as in the repetition, would require a fact-finding inquiry. This court is of the considered view that instead of keeping this repetition pending, the same can be disposed of with a direction to the respondent authorities, more particularly the respondent number 2, to take the said two representations stated so and so and so and so stated to have been submitted by the petitioners before him, comma, on board. And thereafter, comma, to examine the same in the light, examine the same vis-a-vis the procedure laid down by the state government in a notification dated 23/11/2022. Full stop. The respondent number 2 shall examine as to whether there has been approval of the Gaon Sabha in respect of the schemes prepared under the GPDP within bracket Amar Gaon, Amar Asoni by the concerned Gaon Sabha, and also as to whether the construction committees for implementation of the schemes have been duly constituted in strict compliance of the procedure prescribed in the said notification. Or before, in order to pass the speaking order, comma, adjustment number 2 may cause an inquiry if found necessary. Full stop. But the inquiry, but such inquiry. Full stop. It is accordingly ordered. Full stop. It is further observed that the speaking order, the respondent was 2 shall dispose of the said representations by passing a speaking order as expeditiously as possible, comma, but within an outer limit of 4 weeks.
6 weeks. Well,
6 weeks from the date of receipt of a certified copy of this order from the petitioner at his office.
Lordship, the petition may be direct to survey extra
It
copy
is,
of this requisition.
if after passing of the speaking order, if the petitioner found themselves to be aggrieved, comma, it will be open for the petitioner to avail appropriate remedy.
Obliged.
17.
May please lordship, my lord. The petitioner Goshala, Bharatiya Gauraksha Bahini, Sasalpana, Mankeshwar district, Goshala. As per my lord is annexed on page 15. The district magistrate.
Who are you? Is this a registered body?
My lord.
Huh?
My lord.
Registered body?
My lord,
Tell me.
kindly see page 15.
Page 15.
My lord. The district magistrate.
Where is the registered body? 15.
15.
Oh, Hafiz is wrong. This is minority Morta.
Thereafter,
Oh, Mr. Hafizur Rahman
my lord,
and
thereafter,
Rajendra Chandra Das,
my lord.
this order is
Thereafter, my lord, this district magistrate passed an order for permission for seize the cattle to our Goshala.
there is Hafizur Rahman.
My lord.
Page 16 is Hafizur Rahman.
My lord. Thereafter, my lord, this.
You may be a district president of some organization, but this order, page 15 and page 16, is in your individual capacity.
No, my lord.
District President Minority Morsa,
Morsa,
Bharatiya Gauraksha Bahini,
My
South Salmara.
My lord.
That is, you are a president of something.
My lord. My lord,
But this order has been passed in your individual capacity.
to the my lord, Bharatiya Gauraksha Bahini, my lord.
No, Mr. Hafizur Rahman.
Thereafter, my lord, kindly see page 16.
16 also same.
16 also the shifting.
16 also is same.
Settle the, my lord.
Whatever.
Transfer
But
the cattle.
that is why I have asked you. You have presented this writ petition on behalf of South Salmara Mankasar District Committee. Where is that body?
Thereafter, body, my lord, I annex, my lord.
Where is that association? That is what?
Body, my lord, page 46, my lord. Annexure 7, my lord.
Where is the registration? Where is the registration?
Registration, my lord.
And that also does not, this document also does not support. It only indicates that you are president of that district committee. But order has been passed in your individual capacity. How can you maintain a writ petition in the name of that body, South Salmara Mankasar District Committee? Take your call, Mr.
My lord,
Hussain. As prayed for by Mr.
My
Zaid
lord,
Hussain,
the-
Learned Counsel for the petition, will be case on Wednesday. Take your call. Firstly, this South Salmara Mankasar District Committee is an unregistered body. Secondly, the Gosala order has been passed in your individual capacity. Though you may be a president of something else.
my lord, the Rashtriya Goraksha, the
You have not made any statement that it is a registered body. If it is not a registered body, a writ petition cannot be maintained in its name. Secondly, the Gosala order has been passed in your individual capacity, where it is mentioned that you are president of some organization. Gosala order has not been passed in the name of South Salmara Mankasar District Committee. Have you understood?
My lord, under the,
Take your call Wednesday.
my lord.
18. Item 18.
May it please, your lordship, in this case.
High Court. High Court matter.
No, your lordship, I worked as an upper division assistant, I retired, your lordship.
The High Court is involved or not?
No, your lordship. This is the office of the designated judge, Kamrut. Page 24, your lordship, may kindly.
State High Court Counsel. You are a member of the subordinate judiciary.
Yes, your lordship. Subordinate. I retired, your lordship.
You were.
Yeah,
You were then.
Yes, your lordship.
What happened?
Your lordship, may kindly peruse page 24. This is the letter from the senior accounts officer to the Kamrut treasury officer. Rupees 1,80,583 was to be recovered from area and future relief because those were overpayment of pay and allowances, your lordship.
When did you retire?
31/12/2021.
31/12/2021. This order is 2/12/2022.
2/12/2022.
So basically overpayment of pay and allowance.
Allowances, your lordship.
Rafiq Masi.
Yes, your lordship. Then your lordship.
You want to rely on Rafiq Masi?
Yes, your lordship.
Yes.
Lordship, in this matter, AG is the main party, Lordship. They have
AG? So what about the interim prayer? Is there any interim prayer?
Yes, your lordship.
Heard Mr. T. Deori. Learned Counsel for the petitioner. Who is for judicial? Mr. S. Borua. Learned Junior Government Advocate Assam for the respondent number 1. Mr. N.K. Sharma. Learned Counsel representing Mr. S.K. Das. Learned Standing Counsel Guwahati High Court for the respondent number 2.
Lordship.
2
and 3 also, Lordship. Office of the designated judge.
Who are the respondents then?
2, your lordship. 2, office of the designated judge. 3 is office of the principal accountant general A.
You cannot represent 3.
No, Lordship. In my petition, Lordship, 3 is the office.
That was the error, your lordship. It's error.
MS A. Lala. Learned Counsel representing B. Chakraborty. Learned CGC. Learned Standing Counsel. Accountant General A and E Assam for the respondent number 3, 4 and Finance. MS RM Borua. Learned Standing Counsel, Finance Department. Learned Counsel representing Mr. B. Gugoi. Learned Standing Counsel, Finance Department for the respondent number 5. The petitioner retired from service on 31/12/2021 on reaching the age of superannuation, full stop. At the time of retirement, the petitioner was upper division assistant in the establishment of the respondent number 2. Full stop. After retirement on superannuation, the pension proposal was processed by the respondent authorities. Full stop. On 2/12/2022. An order granting provisional CRG has been issued, whereby by the said impugned order, which one? There are 3 amounts, Mr. Deori.
24, Your Lordship. 23 is also the order. 20
Which one? 1,83,000?
Yes, Your Lordship.
Underline.
1,88,583. Underline, Your Lordship.
1,83,583, an amount of rupees 1,83,583 has been sought to be recovered from the petitioner from his arrear and future reliefs. Post of Mr. Deori, learned counsel for the petitioner has submitted that such amount which has been sought to be recovered.
May I interrupt for a moment? Your
Was
Lordship? Your Lordship, may kindly peruse page 26. I have already paid 1,62,648 out of that, Your Lordship.
has been sought to be recovered on the alleged ground of overpayment of pay and allowances. Mr. Deori has submitted that there was no role in the fixation of the pay and allowances of the petitioner in respect of fixation of pay and allowances at the relevant time. And as such, the principles laid down in what is judgment? Tell me the citation.
I'm sorry, Your Lordship, I don't have citation.
Citation.
1 second.
Rafiq Masih versus some washer versus so and
White washer.
white washer versus so and so SCC is applicable. Issue notice returnable on so and so. Return later 26/12 or 28/2. 28/2 as so and so appeared. Appeared no formal notice having regard to the ground on which the amount of rupees has been sought to be recovered from the arrears and future reliefs and the principle laid down in Rafiq Masih Supra, it is observed that there shall not be any recovery from the petitioner's retirement benefits till the returnable date. In terms of the impugned order dated 2/12/2020.
But Your Lordship, I have already paid 1,62,648.
There shall not be any further.
Yes, Your Lordship.
The citation is
There shall not be
2015 4 SCC 334. 2015 4 SCC 334.
Okay, next.
Deep Lords.
Item number 19.
May it please your lordship. My lord, the petitioner is the nominee of two person, my lord, who ultimately, my lord, died, my lord. And being nominee, he filed application before the, my lord, concerned bank, my lord, for transfer of the money in his name, my lord.
Your Lordship, I have received the petition only on 18/1. Thereafter, I have sent the writ petition copy to my concerned department, and the necessary documents by which it can be proved that the writ petitioner is a nominee, that has not yet been received by me. Or neither with the writ petition nor a single document has been attached by which it can be shown that he is a nominee.
My lord, kindly see page 16, my lord, is the report, my lord, of the bank, my lord. His name appear, my lord.
It is
Whose
only one.
report is
Julie
this?
Chaudhary.
Whose report is this? Nomination report. Who has issued this report?
But it's the bank seal is there, my lord.
Bank seal.
Yes, my lord. And below, my lord.
Okay, Mr. Sharma, you can find out.
Yes, yes.
Take your instruction. If he is entitled,
Yes, if he is
entitled,
a
or
nominee,
if
then
he is
there is no
required to
problem.
follow some procedure.
Lordship, that may be, my lord.
That
Otherwise, he
on the
will be
basis of
guided by the
instruction, we can
taxes.
dispose of.
Yes, sir.
Third, Mr. Jiuddin, learned counsel for the petition, and Mr. M. Sharma, learned counsel for the respondent bank.
Sole respondent.
So, respondent bank. So, Mr. Sharma has submitted that he needs
Some time for instructions.
a week's time to obtain instruction regarding nomination details of the petition as agreed to by the land council for the parties. Raise the case on 9 to.
Yes.
My lord, pendency may not be barred because I have submitted representation before.
We don't know.
54. Item 54. Before entering to the merit, my lord, on the 20th, my lord, on 19th, your lordship has my lord, passed an interim order not to take any action pursuant to the my lord, the impugn notice. Now, my lord, on my request, the council also has my lord, intimated to the authorities, and on 20th, after obtaining the certified copy, we have given to everyone. But by that time, my lord, we have already my lord, evicted. Our houses are, everything has been my lord, broken. These are the photographs. Lordship may kindly have a look. Merit will my lord, be discussed, but the non-existence of an my lord, order of this court my lord, in clear terms. Or what other orders my lord, persuaded them to my lord, evict me? Come from the restoration of the.
Yes.
But Lordship may kindly take a note of this.
My lords,
My prayer
we have
will be,
explanation to that. We have explanation to that, madam.
Well,
We have explanation to that. I have instructions.
My prayer is that to constitute a my lord, commission or the district judge may kindly be directed to my lord, inquire into the matter whether this my lord, has been done in violation of the order or not.
It was a
The
Friday.
order is operative. till,
I
my lord,
communicated, my
4:15
lord.
till today.
My lord, but somehow, my lord, some written communications were also sent. So, my lord, they were seeking written instructions, and when they relay, my lord, they received, my lord, it was stopped immediately. To stop. We're not pursuing it further. It has stopped, my lord.
It's already my lord, measure my lord, they all are been represented by council. My lord, the constructive my lord, is that every my lord, authority has the my lord, notice because they are represented by the council.
What
And
are-
on my request, my lord, I have nothing to say against him because he has my lord, helped me out, my lord. He, according to him, he has immediately informed. And we have also my lord, submitted the certified copy on the next day morning, my lord. While the
When it was carried out.
my lord.
When it was carried out.
It was carried out on 20th itself, my lord. Till evening, my lord, everything was complete, my lord.
Okay.
The clear contempt, my lord.
On 20th.
On 20th. 19th order was.
Because there was some miscommunication, madam, they had not received. But there's a bunch of instructions.
My lord, it is apart from this
No, that
certified
after,
copy,
my
whether
lord-
received or not, council is present, my lord, all the respondents are represented.
This is a set of instructions. So, my lord,
Oh, this man, let him come then.
my lord,
This man I have found. I have found on many occasions. Now, without going into the
this
contents, I can
man, this
say.
is the first time he's holding this post.
No, he is holding a post everywhere.
No,
Mr. Gogoi
Well, we,
Mr. Gokul,
my lord, he was in Siriakhana. Then he was transferred to Kachhar. Then Kachhar, there was no this kind of eviction. This is the first time he's holding eviction.
No, but his
My lord, see the
his
explanation.
actions speak for themselves.
Yes, my lord. My lord, will see the explanation, my lord. Once he receives, my lord, the communication, it will stop. Point number 5, my lord. And that apart, my lords, if
Did you not indicate to him?
My lord, after your lordship observation, my lord, we tried to communicate. He was deep inside a jungle. So through a different person, it was communicated.
No, the order was passed on 19-1 and it was uploaded on 19-1 also.
That entire team, my lord,
I made it very clear that upload it on 19-1 itself.
entire team was, my lord. In fact, without uploading, we informed them. It was inside the jungle.
It is not like an order of the civil code.
Yes, it was discontinued immediately.
It was not like an order of the civil code that one has to go and serve it. As soon as the order is passed, it is to be implemented.
Yes, sir. So we tried to communicate. Whenever it was communicated, immediately it was stopped. That is my instruction also, madam. It was stopped.
But his plea that eviction operation commenced on 19-1.
My lord.
Was he inside the jungle since
Yes,
19-1 without food and water?
It was, my lord.
No, paragraph 5.
Paragraph 5, my lord.
Eviction operation commenced on 20.
Exactly, my lord.
20. We passed the order on 19-1.
Yes, my lord.
What is your explanation?
We communicated them, my lord, through even when we could not communicate with phone, my lord, we sent a WhatsApp message also. Whenever
Tell him
the
to come tomorrow.
My lord.
Tell him to come. It's fine.
Sumoto contempt be initiated. I'll come back with
This
the-
PL, I
It
have
was
seen
not-
also orders. I have seen also orders.
This is not.
Eviction from tribal belt. Eviction from tribal belt. PIL Somoto. In tribal belt also, no authority to get title or ownership is permissible. Like in forest land also. By this division bench. And the matter was taken to the Supreme Court in respect of tribal land. The Supreme Court has clarified. Each case is to be considered on a case-to-case basis.
True. Here, my lord, if my lord, there is just one document only, my lord. We have not touched anybody who is having a land document. They say they are having land document, they will not be touched. That is the instruction paragraph 3, my lord, may kindly peruse. Paragraph 3.
No, I am surprised with that.
Nobody will be touched if he is having a land
Case
document.
5. Sorry, paragraph 5.
3 second sentence, my lord. It is pertinent to
Eviction
mention.
operation commenced on 20
Yes, my lord.
at around 10 a.m.
Yes, my lord.
And why he needs a written copy of the order? Paragraph 5.
He may have written, my lord, written copy, but we
No,
communicate.
we will go by that only.
We communicate. My lord, may kindly peruse paragraph 3. The anxiety of the petitioner is taken care of, my lord. Paragraph 3, second sentence, my lord. It is pertinent to mention here that Kursak Paki is an adjacent village wherein the petitioner is claiming to have a document, my lord, to the Kumar Khali Reserve Forest, and no individual having record of land rights Patta is being evicted in the proposed eviction right.
The order
Nobody is
doesn't-
evicted, madam.
Order doesn't contain that. if
Team
they
went
don't
there
have-
doesn't mean,
if
my
they
lord, that
don't
we have
have even
evicted.
a Land documents, so only they should not be evicted. It's all the petitioners should not be touched. My lord. That was the order. My lord.
If now, my lord,
My lord, local inquiry will reveal what has happened.
that was
what
already,
is
there is a
happening.
joint inquiry done. My instruction is that there is a joint inquiry done with the revenue authorities. Then only it was proposed, my lord. And there are 2 orders of the division bench of this honorable court, my lord, wherein we are directed to cause eviction, my lord.
Eviction?
Absolutely
No,
not.
come to
Absolutely
your notice, please, Mr.
Absolutely
Goswami. If this is the notice at page 101.
Yes, my lord.
What kind of notice is this?
Under the act, my lord, there is no scope of notice if a person is residing inside a forest. Besides, beyond, instead of that, there is a notice,
Yes,
my lord.
these kind of orders were passed also in tribal belt as well as in forest land
Yes, ma'am.
by the division bench.
Yes.
That the order passed in respect of division bench is more strict Then the order passed in this,
Single bench.
in this particular, what you have annexed,
My lord, in the
in this
PIL,
PIL,
my lord, in the,
Sumoto.
My lord.
look, my lord, in the PIL, it is specifically said, my lord, as per law, as
And that as per law has been explained by the Supreme Court.
Yes, my lord.
What is the case? এটা আছিল না সেটো সিদিনাখন? এটা আছিল না? In tribal bill.
Tribal bill.
Plus, there also, in accordance with law.
But everything has to be done in accordance with law.
No, then Supreme Court.
About a notice.
No, even if they are unauthorized occupants, the Supreme Court has said it has to be examined, each occupant on case-to-case basis.
That was on a tribal bill in a revenue land, my lord, not in a forest land, my lord. There are two acts which prevents, my lord, Forest Conservation Act and Forest Rights Act. Prevents anybody to reside inside a forest, my lord. Maybe in both the cases, my lord, there can
Both are unauthorized occupants.
unauthorized
I
occupants.
am aware of Section 4, Section 5 of the Indian Forest Act as well as Section 5 of the Assam Forest Regulation. Despite being aware, having been aware of those provisions, now the Supreme Court has said what is in accordance with law.
True, my lord.
That is why I am concerned.
Honorable Apex Court, my lord, perhaps have said in accordance with law, in accordance with the law relating to tribal bill, my lord, not law relating to wildlife sanctuary or reserve forest. Wildlife, we are not doing anything not in accordance with law. Because, my lord,
That is why I wanted Mr. Gogoi to produce the
Notifications.
notification.
Notification, my lord, we have already, my lord, may kindly see the last page of my bunch of document. It was notified in 1966, my lord. I said. 66, isn't it? 66. Page 21 of that bunch of documents, my lord. Name of the forest is, my lord, Kumarkhali Reserve Forest. Page 21. It was notified on 20th of April 1966 at the top of the page, my lord.
Okay, we'll examine 2 at 2. Already 20 minutes past 2. Let me read. Paragraph. The hotspot with regard to human. Is there any necessity to receive any the copy of the order of a High Court?
no, that, no, I'm not disputing, my lord.
No, I am asking.
Copies are not available. We tried to communicate. There was some delay in communicating. The eviction was closed, my lord. But the question is that, my lord, whether during that period, my lord, from 10 to 12, whether these petitioners were evicted or not, they were not evicted. It's not their case that they have been evicted despite their lordship's order. It's a large area, my lord. They have not been evicted. And more importantly, paragraph 3 says, my lord, there is a joint verification of revenue or FIDA revenue.
Understood.
Secondly, my lord, can you see that anybody who is having land records of rights, my lord, Patta, have been excluded. So it is not that my lord's order has been violated, my lord. None of the petitioners have been evicted. It is not there also case that they have been evicted in the.
You have been evicted?
No.
Huh?
Evicted. Well, my clear case, my lord, is very simple, my lord.
No, even all these
order is-
petitioners,
Order
these
is.
petitioners have been evicted.
Got you.
Evicted.
On that day, 20th.
28. Okay.
And in fact, my lord, of the record, my lord, that of course the communication between the councils
my lord, on 20th itself, my lord, I have sent a video, my lord, of my lord, the eviction going on to the council. It is off the record. It's privilege, my lord. My lord, my very clear.
Let their allegation be recorded.
Madam, my submission is, my lord, that order is effective till today. There is no classification whether, my lord, they have pata or they don't have pata. The order is effective till 4:15, and it is an admitted that there some portion have been evicted. To that extent, let it be, my lord, to their voice, my lord, to whatever they are submitted. Some portion have been evicted. I said we are all have been evicted. Under what circumstances they have done it, my lord? Under whose authority they have done it?
Okay, let us have a clear picture. He has placed a state of instruction.
Those are all
We propose, we propose.
I'm totally on the, my lord, effectiveness of the order of
That
this.
is why we are conscious of that fact. We propose to list it on 30 to have an affidavit from this man, this authority, on as regards compliance or non-compliance of the direction made on 19-1. And the interim order shall continue. In the meantime, we'll see the scope of drawing so more to come.
PIL, my lord, clear, my lord, the procedure, my lord, due process of law, my lord. Yes.
If he has done something wrong, we'll see that. Let him, we like to have a statement on affidavit instead of a set of instruction from this authority, then we'll proceed further.
Yes, yes. I don't have any grievance against the councils also. Rather, I said, knowing that the certified copy may not be, my lord, available. We communicated.
Because his statement is, because we passed the order 19, and eviction operation was contemplated on 28th. And he says that upon receipt of the order at 3 p.m., he stopped the operation.
So till 3 o'clock.
Our instructional receipt to Bhatela. I am sure, madam, because I have never procured any order. We verbally informed him and then through Bhatela.
So let him clarify.
Let him clarify.
Mr. P.J. Soikia, learned senior counsel for the petitioner. Mr. P.N. Gusavi, learned additional advocate general. Assisted by Mr. D. Gugoi, learned standing counsel, Environment and Forest Department for the respondent number 1, 2, 3, and 5, and Mr. State Council. Your state. Who is 4? Who is that? He is available or he will be available. And Goswami, Planet Junior Government Advocate Assam for the respondent number 4. Apprehending eviction from the plots of land under the respective occupation pursuant to issuance of a notice, annexed as Annex 14. To the writ petition, by the respondent number 3. That is, English translation is what? Divisional Forest Officer? Or what is Bonohong Mondol Padikari
Yes,
Bikoya?
DFO.
Because you have translated differently.
Some.
That is the Divisional Forest Officer. Gwalpara Division. The petitioners have approached this court by the instant writ petition. The petitioners have projected that which village
my lord, Kasapakri Part 2, Kusapakri Part 2.
They are living, paragraph 5. They have been living in Kusapakri Part 2 since long, and their names are enlisted in the electoral rolls since about 1970. Full stop. When the writ petition was listed before this court by welfare production list, production list on 19/1/2024, comma, this court, while asking the learned Standing Council, Environment and Forest Department to produce the concerned notification whereby the Kumarkhali Reserve Forest has been declared as a reserve forest under the provisions of the Assam Forest Regulation, 1896, had ordered by 22/1/2024, had ordered that till 21/2/2024, no action shall be taken pursuant to the impugn notice, annexed as Annexure 4 to the writ petition. Full stop. Para. By Annexure 14 notice issued under the hand of the respondent number 4, it was informed the respondent number 4, timing the same notice to be the final and last notice, informed, had notified, in general, that the areas under Kumarkhali Reserve Forest would be vacated soon. Full stop. The impugn notice does not bear any date, neither bears any date, nor indicates any period within which the areas under Kumarkhali Reserve Forest would be vacated. Full stop. As the impugn notice has not identified the areas of land from where wherein the eviction process is contemplated, comma, the court requested the Land Standing Council, Environment and Forest Department to place a copy of the notification today. Full stop. When the matter is listed today, comma, Mr. Yeah, Land Senior Counsel appearing for the petitions by placing a set of photographs, comma, has submitted that despite the order dated 19/1/2024, comma, the petitioners have been evicted from their respective plots of land on 20/01/2024. Mr. Puswami, Learned Additional Advocate General, has placed a set of instructions in the form of a community minus set of instruction, white letter bearing memo number so and so dated 21/01/2024, comma, addressed to him by the respondent number 4 or 5.
DFO is 3.
Three, huh? Three. Division of Forest Reserve, 3, huh? Good. Mr. Goswami has further submitted that the eviction process in the forest areas has been undertaken pursuant to direction passed in PIL within bracket Sumoto bracket close number 1 of 2022 within bracket XXX versus State of Assam and other. So, he has drawn attention to an order dated 5/9/2022 passed in PIL Sumoto number 12, wherein a direction was made to the following effect. Got it? Roman 3, Roman 4, Roman 5. It is submitted by him that alleging non-compliance of the same direction, comma, a contempt case, comma, contempt case within brackets C, within brackets Sumoto number 3/2023 has also been registered, and on 19/12/2023 it has been informed by the departmental authorities that the department is planning to conduct eviction drive at a number of areas, including Kumarkhali Reserve Forest. From the letter number, in a letter number so and so dated 21/01/2020, The respondent number 5 or 3?
Due for
3. As mentioned that after a joint survey and verification, it is found that Kursa Pakri is an adjacent village to the Kumarkhali Reserve Forest. First off, he has stated that the eviction was proposed on 20th January to 22nd January 2024. And the encroachers were made well aware of the said dates in advance. Full stop. It is further mentioned that no individual having records of rights within bracket patta is being evicted, was contemplated to be evicted in the proposed eviction right. Full stop. It is mentioned that the eviction operation commenced on 20th January 2024 at around 10 a.m. on 20th January 2024. However, upon receipt of the order dated 19/1/2024, passed in the instant writ petition at around 3 p.m. on 20th January 20/01/2024, the eviction operation was put on hold. Full stop. Since the petitioner's side has alleged non-compliance of the direction made in the order dated 19/1/2024, this court is of the considered view that before proceeding further with the writ petition, an affidavit from the respondent number 3 in respect of the statements made in the letter dated 21/1/2024 appears to be a necessity. Right, the said affidavit shall address on the issue of compliance or non-compliance of the directions made in the order dated 19/1/2020. So place the case again on. Yes, Mr. Rusami, 30/01/2020. The interim order passed earlier on 19/1/2024 stands extended till the next date of list.
Can it be on a later date, on second or so?
You want on second?
First or second?
We thought that on the hearing that pass the order in detail.
In that case, first.
Or otherwise passed.
First.
Otherwise, so many matters are listed. We don't have had the patience to pass a detailed order.
Item 13.
Is it 13?
Timing.
Timing.
May it please your lordship. My lord, here, a short question in what, my lord. What happened, my lord? There was an agreement for sale of a plot of land to me I have paid the entire amount. Now what happened, my lord? The person concerned did not execute the deed after getting permission for sale. Thereafter, what happened, my lord? I filed a civil suit for specific performance of contract. In the civil suit, my lord, I filed an injunction petition also. In the injunction petition, an order has been passed that you should not alienate the property. In that position, my lord, what happened? Subsequently, SDC issued a notice to me that demarcation of the land would be made in favor of private respondent number 8. So, my lord, in that case, I approached the SDC, but SDC is not going to stop that demarcation. That is the thing, my lord. I have filed a
Is the
representation.
civil court powerless to take action?
My lord.
Is the civil court
My
in
lord,
such fact situation?
My lord.
Is the civil court is powerless to take action
My lord, my humble
to stop the
submission-
demarcation process?
Yes, my lord, the civil court has, but
Has.
thing is this, my
And
lord,
why
injunction,
multiplicity of proceedings?
my lord, in injunction is violated. So I can
we have
approach
already indicated
order 39.
Rule 2A
Yes, my lord.
of Order 39.
Order 39. That is there, my lord. But thing is this, my lord. As
Why
this is-
multiplicity of
my
proceedings?
lord, now, my lord, what happened? It is a shoot is not between SDC, my lord. SDC is a government officer.
No, my specific query is
My lord.
whether the civil court who is in seizing of the matter,
My lord.
these are ancillary issues which are appears to be clearly ancillary issues
My lord.
arising out of the same
Right.
subject land,
Right.
right?
Right.
Whether the civil court is powerless to stop the demarcation process. Tell me yes or no.
My lord, only
Be
problem-
specific, yes
Only-
or no.
My lord, only problem is this, my lord. SDC is not party in the civil suit. So SDC, against SDC, civil court cannot do anything. So when SDC knowing very well, there is
Who are the
an-
parties there?
My lord.
Huh? Page 20. Yes, Mr. Goswami.
Page 19, my lord, that Komleshwar Pathak and Gaurikanto Pathak is the defendants. So SDC is not party.
Why, suppose demarcation process, respond number 8. Who is respond number 8?
But respondent number 8 is a private person, my lord, to who is the land is sold out.
Huh?
To whose land is sold out. By
Who-
to who
Same
is-
land.
Same land sold out, my lord, in violation of the interim order of the civil court.
Then Rule 2A is enough.
My lord, 2A is enough, my lord, but as this
Enough.
is-
Stop,
as-
stop
as this-
everybody.
As this is notice, my lord, notice of the SDC is not covered by civil suit, my lord, and SDC is not the party. SDC cannot be controlled on the facts and circumstances, my lord. If your lordship please to direct the SDC, my lord, direct the SDC to look into our representation. And till then, my lord, no further proceeding to demarcation, my lord. SDC very well can examine this. Representation, my lord,
Let him dispose of.
dispose of
Within
the
a period of 1
representation.
month. Till then, no further action on.
Yes, my lord.
To be. Huh?
11-1, all right.
Let him take
No further
a
action. my lord.
decision on this representation on the matter of demarcation within a period of 1 month.
Yes, my lord.
And till then, no proceeding should be undertaken in respect of demarcation case.
Oh,
And matter of demarcation will abide by the final decision.
Final decision of the title.
We'll abide by it. The
Yes.
final decision. Then
Yes, ma'am.
thereafter you
My
take the.
My lord.
Heard, Mr.
M.A. Sheikh.
M.A. Sheikh, Learned Counsel for the petition. And Bordolo, Standing Counsel Revenue Department. For the respond number 1. And then many persons are there. Then we have to issue notice.
My lord, if notice, my lord, in that case, my lord,
And
status can
Goswami
be granted.
Junior Government Advocate Assam for the respond number 2, 3, and 4. Post of. Issue notice returnable on. Hey, আগৰ ফাইলটোত মই দিব এইটো মাৰ্ক এজ হেৰি কৰি দিব ফটোগ্ৰাফ ডকুমেণ্ট এ আৰু সেই সেট অফ ইনষ্ট্ৰাকচন ডকুমেণ্ট বি কৰি দিব হা ৰিটাৰ্নেবল অন কেন ইউ চাৰ্ভ ডাষ্টি
My lord, yes.
2020 as so and so appeared accepted no formal notice extra copies within 2 working days the petition shall take state for service of notice upon the respond number 5 6 7 and 8 which one as paid for the petitioner is permitted to take state for service of notice upon the respond number 5 to 8 by way of dusty also post of you get to the registry compliance affidavit within 2 weeks from today. Post of the petition has projected that in respect of the subject land, an agreement of sale was entered into between the petitioner and the respond number owner,
My lord. 5
and the respond number 6 as the proposed purchaser and
Five
the
and
respond
six.
number 6 as the proposed sellers. Full stop. When despite payment of full consideration or part
Yes, my
consideration?
lord.
Full consideration
4,60,000
against the subject lot. The proposed seller did not execute the sale deed. The petitioner had to institute a title suit, title suit number 349 to 2021 for specific performance of the contract of the agreement for sale of land. Full stop. The said title suit is presently pending before the court of Learned Munship number 1 Barpeta. Full stop. In the said title suit, the petitioner also preferred an application under order 39 rule 1 code of civil procedure seeking an order of injunction and the Learned Trial Court had passed an order of injunction on 29/11/2021 directing the parties to maintain status quo.
No, my lord, your lordship will turn to page 40, my lord. Opposite party defendant not to
40.
align it, the shoot land.
Directing the parties in the suit, defendants in the suit,
Defendant.
including the proposed sellers, within bracket, respond number 4 and 5, 5 and 6, not to alienate
Or create
the
any
subject
charge.
land or to create any charge or interest over a subject land to any third party till disposal of the title suit. Full stop. The petitioner has alleged that despite the said order injunction, despite operation of the said order of injunction, command up respondent number 5 and 6 as the owners of the subject plot had alienated the subject land to the respondent number 8 by way of a sale with the execution of a sale deed. Full stop. The respondent number 8 had, where is that notice?
My lord, notice at page 54.
Ramzan Mia.
Yes, my lord.
Is Ramzan Mia.
Yes, Ramzan Mia.
The respondent number 8 had in comma, in turn, comma, submitted an application seeking demarcation of a subject plot, and the said application has been registered as demarcation case number 121 stroke 2023-2024, resulting in issuance of a notice to the petitioner under the hand of the respondent number 3.
Respondent number 3, my lord.
3. Full stop. In view of such, as the petitioner has projected that the subject land in the title suit is same as the land described in the schedule to the notice dated. Any date?
Date is there.
Huh? No date.
My lord,
Huh?
15/12.
15/12 is okay. Oh,
Yes, 15/12,
2023. Comma, it is observed that till the returnable date, the respondent number 3 shall not proceed further with the with demarcation case number 121 stroke 2023-24.
Much.
Order still indicating item number 20.
No time. We are deciding. Tell me one thing. There is one validity period. There is one claim period. Now, after the validity period, because to maintain a bank guarantee, with a bank, one has to deposit certain charges. Right? Bank charges some fees or whatever. So, there is no doubt that during the validity period, bank continued to charge the petitioner. My next question is whether during the claim period extended beyond the validity period, there was some charge levied. That is an instruction you are capable of getting immediately. Mr. Patwari also. Tell me now. Yes. Mr. Okay. You could try to. Mr. Pathak, there are some decisions on bank guarantee. I remember Himadri, then Binitek. He has given Sumek. What decision you have?
I was also relying on Sumek, another paragraph. Paragraph number 16.
16.
Yes, sir.
Let us see Sumek. It's here somewhere. Okay, if you have a copy of Sumek.
I have.
Okay. What is it? Both are fine on? Yes. Do you have an extra copy then?
Yes.
Let us do it. Because nobody has addressed on the point as to whether a bank guarantee can have a validity period and a different claim period.
Lordship, just I'm thinking out loud here. Lordship. Why perhaps the validity period and the claim period might have to be different, Your Lordship, because
suppose for example, validity of a bank guarantee is 1 year, Your Lordship. And just giving a hypothetical situation. So from 1st of January to 31st of December, if the
And default comes to the notice later on.
comes on the last day, the last minute, then there won't be any possibility of claiming, Your Lordship.
Wow, which paragraph?
Paragraph number 16. Paragraph number 12, the petitioners had already taken, Your Lordship.
Okay. And what are the citations of Himadri and Binitek? I am more conversant with.
Monthly citation is 2007 860 and carrying it.
You have carried. And Binitek?
Meeting I will just
Because once I see those decisions, I'll remember vividly. Because when I was on the other side, so I used those two decisions because it has been, matter have been explained very in detail in Himadri as well as Binitek. Himadri versus HCL. No, Coal Tar. The other one is HCL.
Himadri versus Tarapur and Co.
Huh.
Himadri Steelworks Construction Limited.
Versus HCL, perhaps. That computer company. Okay, let us read paragraph 16 of
Sumek.
Sumek.
clearly, after discussing the judgment, clearly, therefore, the existence of any dispute between the parties to the contract is not a ground for issuing an injunction to restrain the enforcement of bank guarantee. There must be a fraud in connection with such guarantee, such bank guarantee. In the present case, we fail to see any such fraud. The High Court seems to have come to the conclusion that termination of the contract by the appellant and his claim the time of the essence of the contract are not based on the terms of the contract and therefore is a fraud in the invocation of the bank guarantee. That this is an erroneous view. Dispute between the parties during the termination of the contract cannot make invocation of the bank guarantee fraudulent. The High Court has also referred to the conduct of the appellant in invoking the bank guarantee during a clear occasion on 12/4/1923, subsequently withdrawing such invocation. The High Court has used the circumstance in aid of its view that the time was not of the essence of the contract. We fail to see how an earlier invocation of the bank guarantee, subsequent withdrawal of this invocation, makes the bank guarantees or the invocation tainted with fraud in any manner. Under the terms of the contract, it is stipulated that the respondent is required to give unconditional bank guarantee based on advance payment, as also similar bank guarantee for due delivery of the contracted claim in the stipulated period. In the absence of any fraud, the appellant is entitled to increase the bank guarantee. So, Lordship, here what has happened, the petitioner was obligated under the terms of the contract to procure the land and then finish installation of the solar plant. He has not even procured the land. Yesterday he has failed to procure. And there are materials which he has got on record saying that I have failed, kindly foreclose the contract. So that is definitely a ground for termination of the bank.
In a bank guarantee, even if the ground for invocation is found to be without any basis later on, but that would not stop invocation of the bank guarantee. That would not stop the bank from honoring the bank guarantee.
Yes. Now there is one more vital aspect, Your Lord, that in a contract of guarantee, there was a format. The bank has issued the guarantee and it was submitted by the petitioner to APDCL, which has accepted it. Once APDCL has accepted it, as per section 5, the contract of guarantee is complete. So if it has to be revoked, such revocation has to be before the invocation, Your Lordship, and that too by either of the parties to the contract. Here, after the invocation, a stranger is saying that no, it cannot be invoked.
Though he is not a party to the bank guarantee, which is considered to be an independent contract, but the same bank guarantee stood issued at his instance.
So issued at his
for the purpose of entering into the principal agreement.
For the purpose of entering.
That is power purchase agreement.
Yes.
Right?
Yes.
So he cannot be termed as a stranger, but he is not a party to the bank guarantee. But he is not stranger.
He is not.
Because it is he
At whose instance it
whose instant that it was issued, then he carried it to the APDCL. These are the bank guarantees. Now let us execute, or these are the power purchase agreement I have signed. I'm giving it to you.
If at all he had a dispute regarding the he wanted to revoke it, your lordship. That should have perhaps have been done before it was invoked.
Yes, Mr. Patori, you want to say something?
My lord, subject to your
Contractor.
My lord, with your lordship's indulgence, one factual correction, my lord. My lord, they issue a letter of award. And in that letter of award, specifically the validity period is, my lord, mentioned. And in terms of that letter of award, I instruct my bank to issue a bank guarantee stating the same validity period. And thereafter, my lord, it is the bank and the APDCL authorities, they enter into an agreement. I don't go, it's a symbolic, my lord. I don't go and procure the agreement. They keep the original copy with themselves. But the terms and conditions mentioned in the bank guarantee is not, my lord, privy to me.
But that will not.
No, my lord, so
because yes, I thought of it also.
If you also see the bank
I thought of
guarantees,
it also,
my lord.
but annexation of photocopies of all the bank guarantees with that repetition,
my lord,
indicate that you are having photocopies of the bank guarantees.
Yes, I am having what I'm trying to
So-
impress upon your lordship is, my lord, if the bank wanted to insert a clause which is beyond my instruction, like in the case of that Larsen and Turbo, though maybe they were incorrect, but they wrote to the client, my lord,
Right.
that we are going
on
to insert.
29/1/2021,
Yes,
page 78.
my lord. This is my,
You are enclosing the bank guarantees,
yes,
right?
yes. But
Meaning thereby,
But
you are aware of this non-obstante clause incorporated unilaterally by the bank.
my lord, I was aware of the form.
I cannot, you cannot take the plea now.
No, it was behind
This
the bank.
page 82 clause non-obstante, which Mr. Sharma,
Lordship,
as the bank has incorporated unilaterally,
my lord.
going beyond Schedule 3.
Yes, my lord.
Going beyond Schedule 3.
Very true, my lord.
Right?
Very true, my lord.
And because
And-
of page 78,
Lordship will kindly try to page 80 also, 80.
because of page 78, because I'm saying that because because of your statement
Yes, my lord.
that, look here, I'm enclosing the three bank here. Covering letter is that.
Yes, my lord.
And apart from that, bank has covering letter in each of the three bank guarantees. Is it not?
Yes.
Right? Bank has its own covering letter.
Yes.
Over and above that, by page 78. Yes, these are the three bank guarantees which you have asked for as per Schedule 3.
Yes.
Now, and also I have signed the power purchase agreement.
For that purpose, I am enclosing this. But prior to that, Lordship will kindly turn to page 80, those bank guarantees. First paragraph, my lord. First and second paragraph.
Which one, A or B?
Page 80, my lord.
Hmm.
This of agreed guarantee executed on this 25th of January 2021 as Jorhat by the Federal Bank Limited, so-and-so of India, having its head register office so-and-so, referred as the guarantor, which expresses unless be repugnant to the subject to the context thereof, includes so-and-so, in favor of Assam Power Distribution Company. So, my lord, this guarantee is already signed and the original copies are kept by the bank as well as the APDCL authorities. My forwarding is only a mere formality, my lord. I am not party to these terms and conditions. That is what I am trying to impress. And Lordship will kindly see, Lordship, if the bank...
But page 78 letter belies that submission.
No, my lord. My lord, what I'm trying to impress, if the bank wanted to have a validity period and they wanted to go beyond my instruction, then they ought to have communicated to me. This was done behind my back.
Right, that is the normal laws of contract.
Exactly.
Now we are facing that difficult situation.
True, my lord. That was not done. In Larsen and Turbo also, they be maybe under wrong
Now
interpretation
you
of
put
law.
the problem across.
Yes,
You put the problem across that yes, it has been unilaterally incorporated
true, my lord.
going beyond Schedule 3 by the bank.
That is apparent from the record.
And that is also not at the behest of the APDCL also.
But there is signatory.
APDCL has asked for
My lord.
Schedule 3. And this claim period got incorporated perhaps at the instance of bank. And on 29/1/2021, this is page 78 letter. And when they sought to invoke on 1/11 initially, 2022.
23.
23. So what period? From 29/1/2021 to 1/11/2000?
January 23, 2023, my lord.
No. Oh.
22 months.
No. Their impugned letter is on first letter was on 1st November 2000.
Yes, I have annexed that letter, my lord.
Invocation.
First they invoked on, my lord.
2020.
At page
So how is the
98.
period from January 2021 to November 2023? How much?
10 months.
Not 10 months. 2 years. 2 years. Plus
From then, 2 years plus 11, 2 years, 10 months.
10 months.
2 years, 10 months.
2 years, 10 months.
That letter is annexed at 98, page 98.
There's one thing I wanted to contact you about, that this breach of contract was brought to their notice before that 2-year period was completed.
No, that issue is also
And you did not invoke in the validity period.
that issue, apart from the breach of contract in the power purchase agreement, what I have found is that there is another condition to which the petitioner was a party, that Assam Electricity Regulatory Commission.
Yes.
Let us see that order.
Is that page number in my IA or is the page
No,
number?
in the petition itself, perhaps, or in the IA.
I is in the IA. 129 of the IA.
129 of the IA. $129. That was page 131, para 6.
Yes.
Para 6. And if we read 129, then Mr. J.K. Sharma, Abhishek Sharma, project developer, they were present. It was passed in their presence.
Yes.
Project developer.
Yes.
So that stipulated a period of 3 months.
3 months.
3 months. That was apparent default. And fraud and irretrievable injury is not a pleaded case of the petition.
It was not pleaded.
Yes, my lord, it was because it was very hurriedly filed, my lord.
But fraud is a thing which is to be established. Pleaded, not only pleaded. Is to be
in the subsequent additional affidavit, we have pleaded that, my lord. Though not in the petition and not to be.
yes, what is your instruction?
My instruction is also same. After the validity period is over, no charges has been levied, my lord. And my lord, Lordship will not go by the form. Lordship will go by the, my lord, context, my lord. We have in our additional affidavit, my lord, we have taken that.
Additional, because so many pleadings in the writ petition or in the IA, tell me. There are about 15-20 pleadings, in
Yes,
which
yes.
writ petition or in the IA?
In the, my lord, writ petition. It was filed on 7/11/2023.
7/11, okay.
It's
Short affidavit.
short.
One thing, I have found one more inconsistency. I have looked into the records. I did not find any impugned letter dated 4/11/2022. Come to your prayer first, page 18. Prayer A, impugned letter is 1/11/2023. I have found it. That is perhaps at page. Page. Page 98. Right.
Yes, prayer is there, my lord, because they did not give, and in the IA they have annexed that, my lord. We have claimed leave, my lord.
IA?
In the IA 4/11, that is, that was
By your additional affidavit,
yes, ma'am.
which you have just indicated, there is a letter, impugned letter should be 6/11.
Yes, 6/11, my lord.
I think not 4/11.
Yes.
Verify from there.
It might have been a typographical error.
So
It was
I
very
can
high,
consider it to be 6/11.
my lord. And para 2 of that additional affidavit, my lord. May I read it, my lord? Page 104, that the present affidavit is in file to bring on record certain subsequent developments that took place after filing of the writ petition before this honorable court. In the humble comprehension of the petitioner, the said developments have material bearing on adjudication of the case, and as such, the contents of this additional affidavit may be treated as part of pleadings of the accompanying writ petition, that is WPC number so and so. And accordingly, at para 3, my lord, that is humbly stated that the respondent APDCL authorities by communication dated 1/11/2023 requested the Federal Bank authorities for encashment of the petitioner's bank guarantee. However, on 2/11/2023, the said APDCL authorities put on hold the said request for 30 days. Unfortunately, during the currency of the letter dated 2/11/2023, the APDCL authorities again moved the Federal Bank for encashment of the petitioner's bank guarantee on 4/11/2023. My lord, 4/11 was a Saturday, my lord. As such, the petitioner approached the honorable court by way of the accompanying writ petition. Interestingly, during the pendency of the case, the judicial authorities have issued letter dated 6/11/2023 to the senior manager, Federal Bank Limited, whereby the earlier letter dated 2/11/2023 has been withdrawn as cancelled, and a fresh request for liquidation of the petitioner's bank.
That is why I want to know whether there is existence of any letter dated 4/11.
As per our instruction at the relevant point of time when the writ petition was being filed very hurriedly, my lord, on 2/11 when they put on hold, again on 4/11 they communicated with the bank.
Is there any existence in a case record?
In it may not be.
Or otherwise, we can take cognizance of 6/11.
Yes, Lord, 6/11
as a letter impugned.
We have annexed, my.
That is part of the additional affidavit. Is there any existence? No. So we can ignore that so far.
Yes.
Though it is mentioned as 4/11, it should have been 6/11. Because the petition was filed when?
On 6/11 itself, my lord. 4th was a Saturday, 5th was Sunday, and 6th was a Monday.
So that is okay. The facts are in place. What about banks?
And regarding the query to your lordship bank, that what is the Indian bank agent, that answer is given in that Larsen and Toubro judgment itself, my lord. May I read that, my lord? What?
Doesn't appear to have any statutory
backing. Advisory body.
Only advisory body.
All the banks are members. Advisors are writing.
What, right? Why to tomorrow? We can put it tomorrow, but day after tomorrow, we'll pass the order. And if suppose the petition is allowed, then that is a different thing. And if we go by the judgment, I don't have a copy right now of that. Larsen Tubro.
Yes, I'll provide one, my lord. I have.
There it says that there also interpretation is regarding exception trees.
There, your lordship, what appears to be the foundation.
There I found three things.
My lord, lordship, just stand.
Three periods.
Stand up.
In indicated three
Enforcement
periods.
period is also there.
Ah.
Claim period, enforcement period, and.
So
validity.
that is, this exemption tree is relatable to enforcement period.
Which your lordship has said that if it was a government bank otherwise, then it would have been for 30 years. In fact, by bringing it down to 12 months.
And RBI stand is also there.
Because the story of Larsen Tubro is there. I think.
Yes, that is there, my lord. And apart from that.
Because you know what situation?
And apart from that,
Because
RBI
here they got activated. There is slight difference. Larsen and Tubro got activated when they found that how this clause has come.
No, the bank wrote to them, you inside or otherwise we will not issue the bank guarantee.
Whatever.
Yes, my lord.
They did not agree.
So in our case, there was no insistence from the bank, no intimation, my lord. And lordship, para 13 is the RBI stand. RBI was a party, my lord, in that case.
Para
13, 1-3. Respondent number 3 was the RBI. So had the bank written to us, everything will be, my lord, fall into place. Now, my lord, they don't write to us.
Exception 3 to section 28 of the Contract Act does not deal with the claim period at all.
Yes.
Understood.
Now tell me that incorporation of a claim period is legal or illegal, or can be found to be legal? Because
After judgment, I can.
Mr. Patwari, because
My lord.
you have another copy of Larsen Tubro?
Right
No.
now, I don't have.
Come to paragraph 6.
My lord.
Read.
It is further stated that the standard bank guarantee would usually contain the following terms.
Standard bank guarantee.
Yes,
RBI speaks of
standard bank guarantee.
model
Model.
and says that anything should be relatable to exception 3.
Yes.
Now here it says,
Madam.
I don't know whether it is correct or not.
Madam.
Please read. Usually contain the following terms.
Usually, yes.
Ah.
A expiry period, validity period. A bank guarantee would prescribe a specific date by which a bank guarantee would expire. This is a time determined by the principal debtor and the creditor. The right to invoke the bank guarantee is only for default of the principal debtor, which occurs during the validity period of the bank guarantee.
B.
Claim period. This is a time period contractually agreed between the creditor and the principal debtor, which provides a grace period beyond the validity period to make a demand on the bank for a default which has occurred during the validity period. A claim period may or may not exist in the bank guarantee. May or may not exist. The guarantor again has no role to play. So, my lord, it was incumbent to intimate me. That is what I am harping on, my lord.
Understood.
Next, C, enforcement period. The enforcement period is a time period within which the creditor can enforce his accrued rights pursuant to a demand made by him within the validity period or the claim period before a competent court of law. This period, it is stated, is statutorily governed by Section 28B, read with exception 3 to Section 28 of the Contract Act. In the absence of any such clause in the guarantee, the said period would be determined by the limitation. Act.
Yes, Mr. Patwari, you agree to this?
Yes, my lord, in a given
Yes,
case,
Mr. Pathak.
why not?
Paragraph 43, this has been.
No, paragraph 6 regarding 3 dates. And Mr.
Yes.
Sharma. It can have or may not have.
Yes, 2 days will be prescribed by agreement, one by the law, operation of law. That is what they are leading on this.
No, operation of law also does not. Exception 3 also, it has to be agreed.
It has to be.
Agreed, yes.
But that.
Exception 3 is also to be agreed,
Yes.
but that is regarding enforcement.
In paragraph number 43, your lordship, that.
But if we read 82,
Writ petition.
writ petition. Mr. Sharma, you are also agreeable to this? Because I will not explain claim period, validity period, I will quote directly. Then we will proceed further, because there can be or cannot be. There might be agreement, there must be agreement between the parties regarding all the periods. That validity period, claim period,
enforcement period.
and enforcement period. Then we will proceed further.
Yes, sir. That.
These three are, according to that, there must be agreement.
There must be an agreement.
Now come to page 82. By no stretch, it can be made relatable to exception 3.
No.
Except we are approaching the court of law.
For enforcement, because two things. Making a claim
Within the validity period.
is different from making enforcement of a claim.
Yes. Yes, sir. Yes, sir.
Here is a case of making a claim. If the incorporation of claim period is found to be sustainable, suppose, then the demand made either on 1/11/2023 or 6/11/2023 will be found to be valid. Because it will be within the claim period. But if the incorporation is this particular non-obstante condition, in the fact situation is found to be not sustainable, then it goes. And if it is at the instance of the bank, without any consent from the APDC, then that limitation period will survive. Normal limitation period, which means
For
perhaps 30 years or 3 years.
For enforcement.
For enforcement. That is why I said
Yes, ma'am.
making a claim is different from making enforcement, seeking enforcement of the claim.
Distinguishment.
Seeking enforcement of a claim is in a court of law.
True, ma'am.
Making a demand is to the
Bank.
bank. I think there is difference in concept.
True, ma'am.
Paragraph 6 also says that the claim period would perhaps be.
Yes, it is not unusual to have a claim period different than the validity period.
And in that case, terming that.
RBI says model form that does not contain any claim period.
Depends upon.
But it
the-
is not saying that it is some statutorily backed thing. They also say that that other thing is relatable to exception 3.
Yes.
Enforcement.
Enforcement.
True.
So this is the situation and conundrum.
Why this has been done, perhaps if there is a breach on the last day, the last possible moment, then the contractor would not be left with any avenue of making a claim.
But normally it should be by consent. Your schedule 3 is silent.
Bank has, why, that is why I was relying on the 155.
But bank has incorporated this clause on the basis of advisory issued by IBA. And IBA which does not have any statutory backing. It is not even a registered body,
Not even
association of banks,
a-
meaning they have an association of persons.
But perhaps the issue of whether the petitioner was on time to challenge that incorporation, having waited till invocation to say that no, now I have a problem with that clause. For 2 years, he not only did.
I think that is a vital issue.
Yes, your lord.
Lordship
Once
will
he
also,
accepted it and invoked it,
Because exception 3 has to be by agreement.
yes, sir.
And by reading 82, page 82,
my lord,
it does not
and Lordship, perhaps,
indicate that it is relatable to exception 3.
no way, my lord.
Now, only issue is regarding incorporation of claim period, which was not either at the instance of the petitioner nor at the instance of the APDCL. But it remained from January 2021 to November 2023. Problems started arising,
On 1st of November 2020.
but even till the time of filing the writ petition, it was not an issue. Well, writ petition was not structured on that basis. It came later on.
And my lord, perhaps Lordship will kindly consider the doctrine of contra preferentum, my lord, because when there is an ambiguity, the clause has to be interpreted in the favor of the my lord.
No, otherwise there is no ambiguity. How it has come,
That is
is
why,
the
my
issue.
lord. That is why, my lord.
Yes, any idea what your submission will be? Or you have the written submission, tell me an idea so that I can.
That is only on the basis of the claim period and the validity period. It is on the basis of the remedy, invocation and enforcement.
Just give the one page. Not more than that. Not more than that. This way or that way, we'll decide. Without going into, so that we do not have to decide the eyes. Another issue will come, again, we have to direct the petitioner to maintain a bank guarantee or something like that. We will not do, we will decide this way or that way. By anyhow, if possible tomorrow or day after.
Since the bank is already before your lordship, so at least I am protected.
We'll see that if we are not able to pass any order on up to day after tomorrow.
24, 20, that is the last day of invocation of two of the guarantees.
24,
20.
if the claim period is sustainable.
Yes, of course. Yes.
And the third one will be having period
26.
2 more days.
2 more.
Imagery.
Paragraph number 14.
And we need take, in UP State Sugar Sumek, paragraph
We are relying on 12, 13.
12. You are relying on 12.
Yes, 12, 13 and 14, my lord.
I am relying on 16.
And the other one, Vinitex. I'll look into it.
One more. On bank guarantee, same issues have been raised. I'll just give the paragraph.
Let us see. I'll not repeat.
Yes.
Otherwise, these three are.
Same thing.
What is the judgment?
UP Cooperative Federation will Singh consult.
Same.
Same.
It relies on everybody relies on Singh also.
Yes. Same.
And it is year of judgment.
Year 2.
Here, here.
Here is 1988, 161.
1 minute. Sing consultant. Sing consultant. In paragraph 11 of the Himadri, it has been quoted.
As submission for a lawsuit consideration, since there was no consent, my lord, can the element of fraud be brought in, my lord?
What?
Since there was no consent on my part to the bank or no written instruction to the bank that they can extend it beyond the validity period. So apparently it was behind my back. So can the element of fraud be brought in?
I was also thinking about that, but because of your 29/1/2021 letter,
My lord, that is a form. I
that
have to
is
sign the
that is
PPA,
a
my lord.
difficulty.
I have to sign the PPA. That is the form. Originally is already with them, my lord.
Seeing the conduct of Larsen and Toubro and your conduct.
My lord, Larsen and Toubro, that is the difference, my lord. What I am trying to impress upon, lord. The bank wrote to the Larsen and Toubro, my lord. Then they immediately came to the court.
I was putting the question whether it was in express knowledge of the petitioner or not.
It was not, my lord. That is.
It appears to be
No, my lord.
within the knowledge of the petitioner.
Photocopies of the bank guarantees are annexed to the petition.
That is what one thing his letter said we are enclosing under his signature.
So, my lord,
29, page
so, yes, yes.
78.
78.
Secondly, annexing the photocopies of the bank documents substantiate what is there in page 78.
My humble submission in this regard would be, my lord, if, my lord, there was any consent, either implied or in writing, then it would, I would have mentioned in the forwarding letter, my
We'll
lord.
look into it. I am trying to find out a
This
solution.
was a formality. Originally, it's kept by them. They signed it, they keep it, my lord. Just for signing the PPA, I have to give the format I have given, my lord. If the consent was there, in the forwarding letter itself, I would have stated, my lord. And in that reply to their IA,
Because this is a case which is not covered by any of the
Yes.
Supreme Court judgments.
peculiar, my
Not any of the. Though I thought that there is one more judgment. Delivered by Justice Rohington Nariman. There is somewhere where this section 28 has been interpreted. And this has been thought to be distinguished by the Larsen and Toubro. Is it not?
Yes. Because the respondent bank relied on that judgment, my lord.
Do you have that IBA circulars anywhere? Oh. Okay. Just where that Larsen and Toubro mentioned their contention.
My lord, para 4
Para 4.
was the communication which they assailed, my lord.
No, on what ground they have assailed? That is what.
My lord, that.
Somewhere they are large construction company.
Yes, yes.
Somewhere it is mentioned. Thank you.
Paragraph number 5.
Yes. Right. Mr. J. Patori. Learned counsel for the petitioner, Deputy Patrick, Learned Standing Counsel, Deputy Diesel for the respondent number 1 to 4, and Mr. M. Sharma, Learned counsel for the respondent number, respondent 5, within bracket, the respondent number 5, respondent Federal Bank. Mr. Sharma. Learned counsel for the respondent bank. I have submitted that due to bond declared in the first part of the day, he could not obtain the relevant instructions. He could not obtain the instruction before the time of hearing today. Full stop. He has further submitted that instead of an affidavit in reference to the order dated 19/1/2024, he will place written submission tomorrow. Full stop. Release the case tomorrow, Friday.
My lord, and though under the wrong impression of the law, my lord, the PNB in that Larsen and Turbo case, the PNB authorities were insisting on that claim period. Why that, their letter, my lord. And that has been negated eventually by.
No, they are insisting on a certain claim period.
Yes, that is what I'm saying. Though under
We
wrong.
are concerned, first we have asked the query that whether a claim period is an alien concept in a bank guarantee.
It's not, my lord.
It appears to be not.
Not, my lord. But how it has to be incorporated? That is also.
No, that is also clear. That you did not ask for it, the APDCL did not ask for it. Ultimately, it is the bank who appears to have incorporated it. Then the facts are clear. Now we have to decide on it.
Yes, ma'am.
We'll proceed on the basis that claim period is not alien to the bank guarantee concept in the field of bank guarantee, but thing is that that has to be incorporated by consent,
Yes, by agreement.
right?
Yes.
That situation will flow thereafter.
Yes.
Huh?
Section 4, 5, and 6 of the contract act.
4?
5 and 6.
Ah,
When acceptance is complete and when.
1 minute before that, I have to see. Have you looked at, any of you have looked at chapter 8 of the Indian Contract Act? Or you have left the court to look into it? Okay.
Deeply obliged.
এখন ঘুমাই দিও।
Deeply obliged.
Interim order pass. Shall continue till then. It will list that tomorrow. Right?
Party item number 22.
ABT Hawk.
Lordship, I am the secretary of the cooperative society, Lordship. I need to participate in this proceeding. Lordship.
Yes. Somebody. Huh? Okay. Heard Mr. ABT Hawk, Learned Counsel for the applicant. You are the read petitioner.
No, Lordship. I am implementing
Oh, okay. For the applicant.
applicant.
And Mr. S. Bonik, Learned Counsel for the opposite party number 1, that's read petitioner. And Mr. B. Rajkwal, Learned Standing Counsel, Cooperation Department for the opposite party number 2, 3, and 4. Opposite party? We are passing order on I only. Full stop. Mr. Bonik, why have you have preferred the read petition? Okay, the applicant hearing has preferred the instant interlocutory application seeking his implement as a party respondent in a connected writ petition WPC number 6243 2023. First off, the applicant has averred that he is the secretary of Messrs. Dibru Dangori River Part 1 Mean Homobai Committee Limited, which society is the writ petitioner in the connected writ petition. Full stop. Mr. Monique Learned Counsel appearing for opposite party number 1, that's writ petition, and Mr. Rajkwal Learned Standing Counsel, Cooperation Department, appearing for the opposite party number 2 to 4, have submitted that they have no objection if the prayer made in an instant interlocutory application is allowed. Having regard to the fact that the applicant is a secretary of the society, registered cooperative society, who has instituted the connected deed petition, WBC number 6243, 2023. The presence of the applicant as a party respondent in the connected deed petition appears necessary for adjudication of the issues involved in the deed petition. Accordingly, the instant interlocutory application is allowed the office to cause the necessary corrections in the cross title of the connected deed petition by implement of the applicant as a party respondent number 4 on receipt on filing of the amended cross title by the applicant before the registry in terms of the notification number so and so.
One copy of the writ petition, maybe. One
Full
copy
stop.
of the writ petition.
Debatable. Fact finding and inquiry is required.
This one, item number 25.
20.
I'm appearing on behalf of the municipal board. And the request is sent by the
MJ Quarry, Learned Counsel for the petitioner is present. Mr. S. Dr. Learned Senior Counsel assisted by Sir K. Upomoino. Learned Counsel appearing for the respondent, Silchar Municipal Board Authority. Executive Officer 5, Enforcement Inspector 6, Municipal Inspector 7. Appearing for the respondent 5 to 7. Has prayed for and is granted 2 weeks time to file counter affidavit on behalf of the said respondent. Release the case after 2 weeks on a date to be fixed by the. How like? There is no representation on behalf of the petitioner today on call. In view of such non-representation, let the case for instance of justice be listed after 2 weeks on a date to be fixed by the office.
That's 27 and 28.
In this case, today I have filed additional affidavit. Today I have filed additional affidavit.
Additional affidavit.
Press to your. I have given copy. I have given copy to my.
both concerned party, my lord.
Okay, Mr. J.C. Gaur. Right, Mr. J.C. Gaur, Learned Counsel for the petitioner. In his revenue. Mr. N. Goswami, Junior Law Advocate Assam for the respondent 20 and Mr. S.K. Mukhtar, Learned Counsel for the respondent 4 and 5. Mr. Gaur has submitted that an additional affidavit on behalf of the petitioners has been filed today. Is being filed today. So he has thus paid for listing of the case after 2 weeks. We just said, list the case after 2 weeks with the additional affidavit, stated to have been filed on behalf of the petitioner, with the case report.
29 and 30.
Filing, for filing, it is a condition precedent, a copy will be sent to you.
No. Both of you. I think.
Okay. Mr. Gaur has submitted that a copy of the additional affidavit will be submitted to Mr. Mukhtar, Learned Counsel for the respondent number so and so by tomorrow.
29 and 30.
Wilson Inti. Yes. What has happened to Wilson Inti?
Lordship, our lands have been acquired without paying compensation. On the ground that initially it was on the ground that is was under forest area.
Today, for what it has come.
Now, Lordship,
Somebody has not filed affidavit or filed.
No, Lordship, the Karbi Anglong and the Kala has said that our falls under the reserve category. So our areas have been reserved. Therefore, only thing remains that we have to be enrolled in the process of 3A.
Yes, Mr. Chutia. Has the case reached for the stage of disposal? Where is Mr. Taluja? Have you? Yes. Do you intend to file anything or not? If you intend to file, tell me. Or if you do not, okay. Then you say it at the very beginning. BP Bora, Mr. BP Bora, Learned Counsel for the petitioners in both the writ petitions. Both the writ petitions, Mr. J. Sutia, Learned Standing Counsel KAAC. Also heard. And Goswami, Learned Junior Government Advocate Assam for the state respondents. Mr. R. K. Talukdar, Learned Counsel for the respondent number 3 and 10. Or Mr. A. Borua, Learned Counsel for the respondent NHAI Authority. Mr. Talukdar has submitted. Mr. Talukdar, Learned Counsel for the respondent 3 and 10, has submitted that a affidavit, a counter affidavit has been drafted and the same has been sent for vetting. Oh, 3 and 10 file. Who is respondent number 9?
Competent authority for land acquisition, Kalal.
We have filed.
They have opined that we are, these are de-reserve areas.
Okay, so, yeah. So cleaning is complete or not then? Tell me, pleading is complete or not? Then we can fix a date for. Complete.
Yeah. Reading only national highways affidavits remains, otherwise Karbi Anglong.
Yes,
has
Mr. Borua, Borua, do you have any thing in mind to file a counter affidavit or not anything in mind? Okay.
We can
Let us record that.
We have filed the affidavit, my lord, stating that.
Okay. Mr. Talukdar, Learned Counsel appearing for the respondent number 3 and 10, has submitted that an additional affidavit in opposition will be filed on behalf of the said respondents within 2 weeks' time. The prayer to file additional affidavit in opposition by Mr. Talukdar is allowed to release the case. Cases 2022.
But our lanes have been acquired, 80% roads have been completed.
Release the cases on a on a date in the week commencing from 19 February.
Item number 31.
Chandana Goswami Sharma.
In this case, my lord, notice was issued on my lord 24/3, my lord. No
NHAI, Mr. NHAI. Talukdar or Borua, C. Borua. Yes. Acquisition.
Acquisition not, my lord, not acquisition, my lord. Letter of intent issued in the year 2013, my lord.
Letter of intent.
My lord.
Contract.
No, retail outlet, my lord.
Petrol pump.
Petrol pump, my lord.
Then how?
And my lord, kindly
It
see.
should be the petroleum company. Nobody has.
Petroleum company, my lord, in the 24/5, my lord, Mr. S. Borthakur received notice, my lord. Appeared, my lord.
Mr. K.R. Pargiri, Learned Counsel for the petitioner, and Mr. A. Borua, Learned Counsel on behalf of Mr. C. Borua, Learned Standing Counsel, NHAI are present. The subject matter of the petition is award of appointment of retail outlet dealer, my lord, by the respondent. BP Bharat Petroleum Corporation Limited Operated, my lord. Mr. S. Borthakur, learned counsel, who had received notice on behalf of the respondent
356 and
BPCL authorities on 24/5/2023, is found absent today on call. Post of let the case, be listed after a week on a date. Let him come. Maybe because of the day he is not, my lord, appearing.
The date may be fixed, my
After a
lord.
week.
Offline.
Item 32.
Roskill.
My lord, I have seen the case status. I think respondent Deputy Commissioner Revenue has filed a counter affidavit on 3rd January, but I have not got the copy of it.
Ranikhat and Madhubhai, state response in a plot of land which has been claimed to have belonged to the
Others have not filed.
The petition is based on a report. Originally filed.
Served to wrong persons.
Okay.
That's the yes.
Okay, Mr. Heard Mr. P.K. Bora, learned counsel for the petitioner. Mr. N. Goswami, learned junior government advocate Assam for the respondent number 1, 3, 5, and 6. MS N. Borole, learned standing counsel for revenue department for the respondent number 2. Anybody else?
4 also has not.
Education. Okay, you appeared. Somebody A. Pukon appeared. Okay, Mr. A. Pukon. 33. Standing counsel. Education. There may not be one A. Pukon. For the respondent number 4. Mr. Bora, counsel for the petitioner, has submitted that he has been served with a copy of the affidavit in opposition filed by the respondent number 5 today, only today. So he has thus submitted that he would like to go through the same and to file
a rejoinder.
A reply affidavit. If so advised within 2 weeks' time.
Yes, ma'am.
So in view of the submission submit, let the case be listed after 2 weeks.
Obliged.
On a date to be fixed by the office.
Lord will recall this matter where mutation.
I
could
don't
not-
recall anything.
In this matter, mutation could not be carried out, and they had submitted that the revenue map was not available. Your lordships were kind enough to grant me the liberty to implead the director of survey, Dakshin on the last occasion, which I have done, my lord. And then, my lord, the case was listed today for placing further instructions in the matter by the learned state council as regard the availability of the revenue map.
No, this authority has been implemented for the first time.
My lord, but
Okay,
they
today
come
it has
under
come.
they come under the DC, my lord, who's a party. The
No, he comes under Director of Land Record.
But my lord, the website indicates, subject to correction, my lord,
If If we go by the
Land and revenue regulations and the Assam Land Records Manual, then it is an authority under Director of Land Records.
I stand corrected, my lord.
Because he acts on behalf of, for all the districts,
My lord.
not only confined to one particular district.
My lord, but the website indicates that DLR is overall in charge of maintenance and updating the land records of the state through the circle office under the deputy commissioner.
In many of the orders, Director of Land Record is an appellate authority.
My lord.
His position is higher than the jurisdictional deputy commissioner. His jurisdiction is over entire state of Assam, not Kamrup district.
My lord. My lord, maybe my friend might be able to take instruction because she has to take instructions from there, and they had actually written to the director.
Here, Mr. Phukan.
Yes, my lord.
Now comes, I think, the standing revenue.
Because they had already written, your lordship had
No,
written that.
Mr. Phukan.
My lord.
Earlier, Mr. Phukan appeared and State Council appeared. Junior Government Advocate appeared. No, now what? Okay. Anyway, joint survey is party, joint director. You are standing council. Okay, now we have to send notice. Today you will be receiving notice. Okay, heard Mr. A. Phukan, learned counsel for the petitioner, and Mr. N. Goswami, learned Junior Government Advocate Assam for the response number 2, 3, and 4. Also heard MS Z. Hazarika, learned standing counsel Revenue Department for the response number 1 and 5. Notice be issued. The pursuant to the order date 11/12/2022, the petitioner has filed amended cost title.
My lord had also.
And accordingly, comma, care of the necessary corrections have been made in the area of respondents by implement of the party respondent by implement of the joint director of service, Assam of Kingaon, Guwahati, as party respondent number 5, which public notice be issued to the newly read party respondent number 5, as Ms. Hazarika, the standing council revenue department has prepared and accepted notice on behalf of the newly read party respondent number 5. No formal notice need to be issued. You need any extra copy? Okay, Mr. Phukan, learning counsel for the petitioner, shall furnish an extra copy of the petition to Ms. Hazarika, learning counsel for standing of revenue. During the course of the day, you have extra copy today or
I'll serve
by tomorrow? Post of Ms. Hazarika, standing counsel, revenue department shall obtain instructions as regards the survey.
My lord had crystallized the issue in your lordship's order of 8th November, my lord. Thereafter, on 20th November, your lordships record that the reason for the mutation not happening was non-availability of the map.
As regards the revenue map, in respect of the land, plot of land in question, comma, as indicated in the communication bearing number GC to Agora Road dated 8/12/2023 of the respond number 3. Full stop. MS Hazarika as short for notice returnable helicopter as sought for listing of the case on
A request for 19th, subject to convenience, your lordship, 19th of February.
okay 19 to 2023 to obtain instruction as regards the availability of the revenue in respect of the land, plot of land in question.
Deeply obliged.
Number 34. Anwara.
May I plead your lordship? Lordship, petition
Yes.
elected ex-president of 241 Nang Bhatia Kheligaon Panchayat in the district of Nagaur.
Remuneration.
Yes, lordship.
Dotto, where is Dotto?
Same matter already disposed of.
Okay, we are fixing a date, fixed date, then we'll dispose of. Mr. Dotto is also not available. Mr.
M. Hussain.
M. Hussain. Hi, Mr. M. Hussain, learned counsel for the petitioner. And Mr. M.S. P. Vishwas, learned counsel, appearing for Mr. S. Dotto, learned standing counsel, Panchayat and Rural Development Department. M.S. Dotto Vishwas has prayed for further 2 weeks' time to obtain up-to-date instructions regarding the status of the process of release of remuneration to the petitioners.
Yes.
Place the case on it was 16 to.
Obliged.
Number 25.
May I please, your lordship? May I plead that the matter may be listed on first week of February, your lordship?
First week of February.
Lordship.
Okay, Mr. UK Deka.
Lordship.
Learned counsel for the petitioner has prayed for listing of the case. In the week commencing from 5th of February. On a date in the week commencing from the 5th of February 2024. Mr. A. Sharma. Okay. And who are the state? MS and Bordoloi, standing counsel revenue 1. And Goswami, junior government advocate 2, 3. And Mr. A.K. Sharma, learned counsel 4. Learned counsel for respond number 4 to 7. 8, 9, 10, 11. You are not there. 4 to 11. Okay, 4 to 11 are present. Posto. How is the case in the on a date in the week commencing from 5th of February 2000.
Interim order, your lordship.
Interim order? No. Have you filed any affidavit?
No, sir.
Any interlocutory application? No, have you filed an interlocutory application by the next date?
Problem.
Interim order passed earlier shall continue till the next date of.
Item 37.
Mr. Ajedas, I could not correct because of some other engagement.
No problem.
You'll be getting it tomorrow, dear.
Wait, well, on the last occasion, that is, my lord, on 18/12/2023, my lord, your lordship was pleased to issue notice. Perhaps an affidavit will be.
No affidavit.
In fact, earlier,
not be reflected in the report. That is why appropriate notification should not be. Now, the authority has communicated to us. We will do that. Already mentioned for you.
So it can be disposed of. Well, today it will be very difficult. Mr.
AK. And my lord,
Maybe on next today's
22nd.
Okay. 29 or
38, my lord. 31st. On 29 or 29.
31st holiday. 29 given. 31st holiday. 29 given. Okay, Mr. Burwa.
My lord.
2nd of February.
Second one. My lord, may I pray a copy of the instructions so that, my lord, I can also come with my own.
It has been reclassified from AL to NOVA, residential class. Accordingly, 3D notification will be passed. So let me have a look, then I pass the order.
Can it be taken up on 5th of
Okay, 5th of February. As Mr. Heard Mr. A.K. Burwa, Learned Counsel for the petition, and Mr. B. Goswami, Learned Additional Advocate General, assisted by MS N. Bordove, N. Goswami, and Bordove, for all the respondents. All the respondents? No. For respondent number 7, 8, and 9. Also had Mr. A. Burwa. The standing counsel. Learned counsel appearing for Mr. C. Burwa. And standing counsel NHAI and NHIDCL for the respondent number 3, 4, 5, and 6. So Mr. Goswami, Learned Additional Advocate General, by placing a communication bearing number so and so dated 11/1/2024, has submitted that this is from Kala, I think. Kala, from the Additional Deputy Commissioner, from the respondent number 8, has submitted that the classification or lane has been changed to residential class in the meantime, and necessary steps regarding issuance of notification under 3D under the NH Act 1956 will be published in a due course within a short period. So, as agreed to by the Learned Counsel for the parties, leaves the case on 5/2/2024, as the parties have submitted that the repetition can be taken up for final consideration on the basis of the available records.
Interim protection may continue.
The interim protection partially shall continue in the meantime.
Well, a copy of the instruction may be provided.
Only one.
Okay.
I'll xerox and I'll give it.
Give a copy. Okay, it will be given. Get in contact with the court master, it will be given. A copy of the communication bearing number so and so is to copy. Whatever is to be kept with the case record. You collect one copy.
I'll collect.
You collect the original or photocopy, you can retain.
39 and 40.
What is this series of petitions?
My lord, during the pendency of the review petition, my lord, the appellant payment had expired. So, my lord, substitution has been filed.
What are the cases?
My lord,
Give a gist first. What are I'll not open the first. This IA is for this IA is
My
for
lord,
this
my
IA
lord, my
is
lord.
for- Give a list and we'll
My
take
lord,
up.
my lord.
On so,
My lord,
yes,
I
for what? Basically, one CRP and one MSc appeal.
My lord,
What?
CRP is for revision was filed against the Bakijaya proceeding which was initiated. And that, my lord, notices were issued and, my lord, the matter was.
Why CRP is before us then?
My lord, this was tagged
Because-
because of an order passed by this honorable court.
Review of the MSc judgment?
Yes, my lord. Yes, my lord.
No, what is to do with this?
In the meantime, my lord, the claimants, my lord, proceeded and they filed the Bakijaya proceeding. Against the Bakijaya proceeding, we had filed a revision petition.
Other, we are not the roaster
My
mans
lord.
for CRP.
My lord. There was an order to that effect.
So we'll decide this MSc appeal
My lord. My lord.
and review petition.
My lord.
Thereafter, we'll
My lord, at
send the CRP to the
to the relevant.
appropriate bench.
My lord.
That can be done.
My lord. My lord,
So,
the IA.
this MSc appeal
My lord.
is already disposed of.
Disposed of.
Then what is pending
The
in that connection?
there was, my lord, the award was enhanced, and my lord, my lord, judgment was passed by this honorable court. My lord, after that, it was my lord, it was learned that the review petition was filed before the tribunal, and that review petition and the miscases which were before the tribunal were never brought before this honorable court, my lord. So, with an understanding that it was simply an enhancement of a death case, in a death case, my lord, the award was enhanced. So we have filed a review petition of the judgment, my lord. The appellant claimants were the appellant in the MSc appeal. They filed an appeal for enhancement of the award. We were respondent, insurance company.
On what date the appeal was disposed of?
My lord.
On what date the appeal was disposed of?
My lord.
13? 13 to 2019. Okay. When those review petitions were filed?
Those review petitions were filed in the my lord, main before the tribunal initially.
When? Before 13/3/2019?
My lord, yes, my lord.
What is the exact period? 17, 18, 19? First, we'll examine
my lord,
about. First, we'll examine about due diligence.
My lord. Lordship.
13.
Lordship, at this stage, what I pray before your lordship is, there are 3 applications because they have informed that the appellant claimant had died. Because of that, these 3 applications are filed before your lordship. One is for
Okay.
setting aside the abatement, one is condonation and substitution. my lord. If this can be disposed of today, taken up and disposed of,
No.
then my lord,
I
we
have
can
to
go.
Back to one Bengali
Seven
issue
to-
is there. I have to seek for that.
7 February.
7 paper.
My lord, then,
Hearing date or due? Hearing date or due?
my
Yeah,
lord,
yeah,
I
did you?
have some difficulty, my lord, during the month of, 8/15. My lord, during the month of February, I have some difficulty. My lord, either it can be on 29th or 30th, my lord. On 2nd onwards, my lord, I am not in town. 29th. my lord.
29.
20.
Okay. Basically, which application is to be considered?
156061 and 1558. 58, that is condonation application.
1560.
1560 and 1561.
1561.
My lord.
These are in CRP.
My lord, there are.
Tell me which are the application in MSc appeal. Huh?
These, my lord, applications
What is
are
the
review.
review petition is shown as filing number?
My lord. Because it was not, there is a delay, my lord, still delay.
Okay, basically we have to consider this one, IA Civil 2070,
Yes, my lord.
along with the review petition.
My lord, along with the review.
This Bakijaya is subsequent to MSc appeal.
My lord.
Where? There is no substitution in the MSc appeal.
Not MSCP in review petition, they have filed one IA for delay condonation. In delay condonation petition, they have filed.
No, in MSc appeal also, those are required to be filed. CRP is independent. Is it not? CRP is against Bakija proceedings. MSc appeal, it is different.
It is review file. now.
Review file.
There is delay.
There is delay. In the meantime,
Payment.
expiry. Then I think application are required to be filed.
My lord, we have filed. These
Where it is
applications are in
shown.
condonation application only, my lord.
Then in the other cases, if the substitution is filed. Have you understood?
My lord, this,
They have filed 6 applications.
these are, my lord,
No,
actually.
this cause list is showing
My
all
lord,
these
this is
IAs in CRP.
Wrongly, my lord. It's
Then
reflecting
identify
wrong.
me.
My lord, these are wrongly, my lord, reflecting. This revisions, my lord,
1560 rejection.
কোনটো দেব আমাৰ এতিয়া?
1588, 1560 review. 1558. 1558.
1558.
Now 1558. Okay, then
1560.
1560. Some mistake is there.
In the application. That's what, my lord, I inquired from my colleague. She said that everything is okay.
No, strike off.
Strike off.
Without any signature. No,
Oh.
and number of MSc appeal is not appearing.
No, because, my lord, MSc appeal was not registered itself. My lord, we will, my lord, make corrections.
It has to be filed.
Yes.
It has to be corrected before the registry.
Then all these 3 IAs we will withdraw and then file afresh.
Because it will be difficult.
Because we have, my lord, indicated the IA number, which is a condonation application in review petition.
But condonation petition, let us see 2070. 2070. It's CRP to CRP.
This condonation is in review application, my lord.
2070.
My lord.
Okay. Okay. Hi, Mr. R.K. Batra, learned counsel for the petitioner. And MSP Oras IG. Learned counsel. Appearing for the claimant within bracket since delays. The Mr. Batra, learned counsel for the petitioner submitted that IAC number 2070-2020, comma IAC number 1558
of 2023.
2023 and
1560 2023.
IA 1560
2023.
23.
My lord.
These three.
And 1561.
And IA C number 1561 2023 are all have all arisen out of the review petition 7617-2020 within bracket filing number. And the same stuff, he has submitted that the same can be together on the next date of listing. Okay, raise the case. When you will be available?
29, my lord. 29.
Raise the case.
29th or 30th, my lord, whatever is convenient.
29.
29th is a Monday.
2000, 24 along with বাকিবোৰ লিখি দিব, বাকিবোৰ লিখি দিব. Then I can find out the cases. Otherwise, 10, 12 IAs have been filed.
Oblige. Sorry for the inconvenience.
Oh.
my lords.
41 and 42.
Bureau of order passed to the
Please-
clerk.
please,
Once
sir.
the inquiry is concluded, and council is according direct to amendments hospital, let notice be issued to the students. Yes,
Service is awaited, my lord.
service is everything.
Awaited.
You are appearing for? One. Mr.
HP Gwala, my lord.
HP Gwala, learned counsel for the petition. Mr. D. Nath, learned counsel for the respondent number 1. Are present. As per Mr. Nath has submitted that he has received the instructions, necessary instructions to file the counter affidavit, and accordingly, the same will be filed within 2 weeks' time. So stop. As per office note dated 21/12/2023. Notice has been issued. No.
Well, office note 11/1, my lord.
Ah. In view of office note, as per office note dated 11/1/2024, neither the ID card nor the answer notice has been received back from the respondent number 2. Raise the case after 2 weeks for filing of counter affidavit by the respondent number 1 and for service report in respect of respondent number 2.
Oblige.
Item 43.
It is why 41 and 42 tag together means same. Okay. Similar purpose to it.
Sure, item 43 is a review petition, your lordship. Lordship, may I pray the matter may come up on 2nd, your lordship, 2nd of February. Second of February.
Okay, the pair of Mr. and Gautam learned talk for the petition. Please the case on 22. Mr. D. Nath, learned counsel for the learned additional senior government advocate for the state respondent, please in action.
44.
ভূমি অধিকৃত কৃষক সমিতি
Lordship, as per order dated 2011-2023, the sole respondent is supposed to file
File
a-
affidavit.
Lordship.
What is the order? Let us see the order.
Lordship, at page 13. No,
Page
it's not.
13.
Lordship.
The requirement of making assessment of interest payable admissible under law to be done.
Lordship,
This
para-
is regarding what? Interest.
Interest. Lordship.
Soresium.
Lordship.
Is made that according to accreditor shall make the necessary arrangement for making the fund available and process into the payment. Yes.
I have written instruction that obviously we have sent a proposal to the finance department on the 12th of October 2023. Now what I have instruction that Krishna has already received the amount.
No, Lordship.
Get the instruction then.
No, Lordship.
No, when did you contact your client? 2023?
No, Lordship, just after Bihu, on Friday, last Friday.
Then get definite instruction.
Yes, sir.
Mr.
Hi, Hassan.
I. Hassan, learning counsel for a petition, and Mr. M.S.R. M. Deka, learning counsel for the sole respondent. Full stop. M.S. Deka has submitted that she has received instruction that the necessary amount has been disbursed to the petitioner. Full stop. She has, however, submitted that has submitted for listing of the case after 2 weeks in order to enable her to obtain definite instructions on the said aspect. As prayed for by MS Dekal and consultant petitioner, is the case of it.
Lordship, kindly dates me. Can
Money is gone. Yes, Mr.
My lord, order dated 28/3, my lord, the office order,
28.
that may kindly be seen, my lord. My lord, notice has to be sent to respond number 7, my lord. Earlier it was
No, no,
returned.
In which case? In a IA or what?
No, in the main case, my lord.
Main case. To Anjana Hava Pandit.
Yes.
Yes.
My
What
lord, the
is required?
office order dated 28/3, my lord.
28.
23.
Case none appear. Office revision notice was issued to Asmat 3 foreign by registered court. Here's the only concern entered at 3 and the biological service is deemed to be complete. You want to send a press notice at this address?
At this address and plus two other addresses of the same man, my lord, that we have mentioned in page number 6 of our IA, my lord. So three addresses we want to send, my lord. One given.
Mr. B.D. Goswami. Learned counsel for the applicant, that's writ petition.
Yes, ma'am.
For a writ petitioner in WBC number so and so. And for the applicant, that's writ petition. And who are the others?
And they are represented except respond number 7, my lord.
You want to serve this notice?
On respond number 7.
Oh, that one, Jurhat.
Yes, my lord.
Huh? Jurhat office.
Jurhat office is one, my lord. That has come in that office note, plus two other addresses.
No, I remember, no, when you moved the writ petition.
Yes, my lord. That is.
Anybody? Mr. N. Goswami? Learn it. For the opposite party number 6. None has appeared.
No, my lord, my friend.
Yes, Mr. Please come forward. Mr. P.H. Kaur. Kaur. K-A-R. Kaur. Kaur. Learned counsel for the opposite party number 3 and 4. None has appeared for the OP number 1, 2, and 5. Full stop. The petition applicant, who is the writ petitioner in the connected writ petition, WBC number so and so, has preferred the instant interlocutory application in view of the office note. In view of the order dated 28/3/2023, passed by the Lohajima Court in the said writ petition. So stop. As per the in the order dated 28/3/2023, the Lohajima Court has observed that insofar as the notice sent to the opposite party number 7 herein, i.e. that is the opposite respond number 7 in the connected petition is concerned, the said notice had returned unserved with a new address written on the envelope of the returned unserved notice to the following effect. Yate, I do. Hold on, in the instant interlocutory application,
But in addition,
the petitioner
yes.
has ever that apart from the aforementioned address, two new addresses of the opposite party number 7 within in the hearing, that is the respond number 7 in the connected petition, are found as under
Page 6.
Page 6. The instant interlocutory application has been preferred by the applicant writ petitioner with a prayer to permit the applicant writ petitioner to take steps for service of notice upon the said opposite party number 7 hearing, that is the respondent number 7 in the connected writ petition in the aforementioned 3 addresses by registered post ready. Post of the prayer made in this interlocutory application is allowed. The petitioner shall take steps for service of notice upon the opposite party number 7 hearing, that is the respondent number 7 in the connected writ petition by registered post with AD within 3 working days from today in the aforementioned 3 addresses. Full stop. The interlocutory application stands accordingly disposed of. Full stop. The office to record the service status of the notice in the notices of the connected writ petition WBC number. That will expedite?
Yes, much obliged, madam.
Yes, anything interim order? Yes.
Item number 55,
55.
supplementary list.
Okay. You are for private person or private?
Both are private party.
Okay. Okay, okay. It is principal goals. Oh, I thought that is.
I guess the charge was judicial officer.
Huh?
I guess, one is a judicial officer.
The pertains to Kohima bench, but at that relevant point of time, the bench was not able, so it was moved here.
Or whatever. Mr. You want to file some?
He has already filed a IA for vacation of the interim order. I have to
Okay.
file an objection to that thing and the interim order may be extended.
Okay, we'll record it only. How much time you need?
Lordship, since in this case I'm being led by Mr. Kane, so this since vetting will be required, at least 4 weeks will be required in this case.
Very urgent, madam.
It's because his vetting will be required.
Only for a temporary period, temporary time. They have mentioned in paragraph 10. Paragraph 10, they have mentioned, madam. If 257, it is not filed, they are filed during this week because of the, madam, that period of time it was, the court was on vacation. That is the only reason. That was filed, for a temporary period. That is something paragraph 10. This is regarding custody of minor child.
There's allegations regarding biasness. So those things will be brought on record. It is already on board.
This is regarding custody.
Custody, this is a custody order which that was filed out. So that aspect, so Lordship, at least 3 weeks time.
Filed the interlocutory application within 2 weeks.
No, they have already filed the interlocutory application. We filed an objection.
No, objection.
Objection.
2 weeks.
Okay, Lordship. Oh, yeah, 2 weeks. 2 weeks, 2 weeks.
2 weeks. 2 weeks. 2 weeks. Fixing a date. Heard Mr. RJ Das, Learned Counsel for the petitioner. And opposite party in the petition, and for the opposite party in IS Civil 185/2024, and Mr. P. Khatune, Learned Counsel for the respondent number 2 in the petition, and the applicant in the interlocutory application IAC number so and so. The interlocutory application has been filed seeking vacation stroke modification of the order dated 22/12/2023 passed in the repetition. Mr. Das, Learned Counsel, appearing for the writ petitioner as opposite party has sought for 2 weeks time to file an objection to the interlocutory application. The prayer made by Mr. Das is allowed. 1 by striking 1 week.
Lordship, any date after 7 because senior will be joining only after 7.
9?
9.
Place the case on 9. The interim order passed, right? Will continue.
Deeply obliged.
Any interim order? Extended to be extended?
48. A date may be fixed, my lord.
No. Interim order or
No
not?
interim, my lord.
No interim, then no. Persuade the court master for that.
Highly obliged.
Any interim order? Any early fixation?